The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near, and they will be heard. God save the United States and this honorable court.
Please be seated. We have a full load today. We're going to hear 6 oral arguments. We'll probably take a break after the third, maybe the fourth, maybe the second, sometime, depending how things go. We'll start with 22-3166, We the Patriots versus Grisham.
Morning, Your Honors. May it please the court, Pete Patterson for the Fort plaintiffs. I'm going to be splitting time with the Donk plaintiffs. We're going to try to do 10 and 5, and I'd like to reserve 2 minutes for rebuttal if we can. The governor's order is antithetical to the Second Amendment and should be enjoined. The order is premised on the notion that there is a crisis of violence in Albuquerque and Bernalillo County, and that is a time when the need for self-defense is most acute, not when it can be taken away. The founders were familiar with areas that were particularly vulnerable. And what they did in those locations is that they didn't disarm people. Instead, they required people to be armed. So the governor's order is directly contrary to the principles that underlie the Second Amendment.
Well, Counsel,
Yes.
I'm a little confused. The district court in another case, Springer versus Grisham, granted the preliminary injunction that you're now seeking on your behalf. But it's done, isn't it?
It's not done because a preliminary injunction is just that, preliminary.
I understand
There's
that.
no guarantee it's going to last for the duration
Well, but
of
right
our
now,
case.
you got the relief you wanted in this other case. So if we granted your motion now or your appeal now, what would it do?
Well, one, it's going to guarantee that that stays in place for the duration of our litigation.
Speak into the microphone a little.
I'm sorry, Your Honor.
Thank you.
One, it's going to guarantee that it stays in place for the duration of our litigation. And two, it's not clear that that injunction covers us. Springer is an individual. There is one plaintiff in that case. The United States Supreme Court recently vacated an injunction in Labrador versus Poe to the extent it went beyond the named plaintiff in a case because it wasn't necessary to give him a relief. And so it's not clear that perhaps that injunction does cover us now, but even if it does, that could be a weakness in the injunction that could render us not protected.
Did you make that particular argument in your supplemental brief?
Well, we noted in the supplemental brief that it could be, there were issues with the injunction that could cause it to be narrowed, including that it purports to enjoin the order
move,
and not the...
et cetera. But did you make that specific argument that you began with in responding to Judge Kelly, that this preliminary injunction in Springer related to an individual that wouldn't necessarily relate to your particular
We didn't make that
claims?
specific argument. We made the argument that the injunction purports to enjoin the order itself rather than an official, which is
Okay.
not the normal form for an injunction. Then this is related in that the order does not give clarity as to who the injunction protects. So, and this is similar to the Ninth Circuit and 11th Circuit cases that we've cited, which said despite nationwide injunctions, we're still going to enter an injunction on behalf, or consider entering an injunction on behalf of the plaintiffs in the case before us.
What about redressability here?
Yes.
Because from what I can tell, any place in Bernalillo County that you're covering already has an ordinance, some legal prohibition against carrying a firearm in those places.
Yes, Your Honor. So the first answer on that is that the New Mexico Constitution preempts local firearm laws, and there's a New Mexico Supreme Court decision, BACA, that says that this bars concealed carry bans in localities.
Don't you have to get that resolved before you seek relief in federal court?
We don't have to get it resolved, and this is a distinction between the cases the other side cites and that in all those cases, redressability was dependent on, or most of them, was dependent upon actions of a third party, whether the cockfighting market would come back, whether somebody would contract with them, whether an employer would impose a vaccine mandate. Here, if this order is enjoined, our clients, they don't have to rely on anybody else. Fort has said he would carry if this order was enjoined, so that would redress the harm.
He said he would.
He said he would if this order were enjoined, notwithstanding any other local jurisdictions. And the Smith and Donk have both said they're still carrying now, despite the fact that this order is in place. So the harm that they're facing is.
But we would have to accept your argument, we would have to make our own determination of New Mexico constitutional law, would we not?
You wouldn't have to. I would submit that the New Mexico Supreme Court has already resolved this, and we've got an Attorney General letter saying that a location-specific ordinance couldn't stand.
Court hadn't ruled.
So
how
I think
does
it's
that
straightforward, but you would not have to, because again, you don't have to redress all of our injury. Every potential injury that we've had, our clients have said, if this order is enjoined, we will carry. And so that means that the injury we are facing from the governor's order will be redressed by what this court does. Maybe we will face some other potential injuries. We don't think so due to the New Mexico Constitution, but this court does not have to make that determination in order to rule in our favor. And so briefly touching on the merits, I would like to say the governor overwhelmingly relies on municipal park regulations from the late 18th century to support the order. First of all, those had nothing to do with an emergency circumstance. New Mexico is fine generally with carries in parks. The premise here is that we're having an epidemic of violence. As I said, there's no principle in history that would allow bar and carry in that circumstance. But even putting that to the side, these are too little and too late. Our submission is that the date is set in 1791, as you know, but even if it were 1868, there were only 3 of these municipal regulations by 1868. And also, what is important is that Bruin teaches you have to look at why these regulations are in place. The governor has not explained why these park regulations are in place. Even if they assert they're a dead ringer, that doesn't matter. Bruin said, assumed for sake of argument, there were some handgun carry bans in colonial times, but they said those were because handguns were dangerous and unusual weapons then. They're not now, so we have to know the why. And if we look at the why in these parks, it readily becomes apparent that these parks are a departure from our national traditions, not something that we should be drawing constitutional values from. These were an effort to create idyllic, rural, aristocratic type spaces within cities. And you can see that from the regulations that were in place in these parks, such as no ball playing, no musical instruments, no walking on the grass outside of the lawns, no indecent language, and yes, no firearms. But in context, what that indicates is that the worry was that people would be hunting or target shooting and thus disturbing the tranquility of these locations. This was not about public safety. And then the Schuyler source that the governor cites says that when Prospect Park in Brooklyn was being made in this mold, Olmsted urged them to purchase an adjoining parcel for another park that would allow active recreation, including military training exercises. So these parks were essentially, if you would look at it in the First Amendment context, a time, place, and manner sort of regulation for putting activities in various places, but it's just apparent that this is not something we should be drawing our tradition of firearm regulation from, even if it were not too late. And I will pass the time on to my co-counsel, so hopefully we can reserve a few minutes for rebuttal. Thank you.
Good morning, Your Honors. Anthony Napolitano for Plaintiffs of Appellants, Gun Owners of America, Gun Owners Foundation, and Randy Donk. May it please the Court, I intend to specifically address the issues of playgrounds as affected by the New Mexico Public Health Order and the Donk plaintiff's departure from the other plaintiffs. In footnote 7, the assertion that the Supreme Court has not ruled that any place is conclusively a sensitive place. The Court merely discusses that possibility in dicta, and the rules
In Heller?
In Heller and in Bruin, Your Honor.
Well, yeah, and in Heller, which you refer to as dicta, with regard to government buildings and schools, Judge Abell, speaking for a unanimous panel in a published opinion, held that the dicta for government buildings does bind our panel because we are typically consider ourselves bound as much by Supreme Court dicta as much as holdings. So why doesn't Bonady's prescription for binding us to the dicta on government buildings bind us also to the Heller dicta on schools?
Your Honor, the ultimate problem here is that Heller did not address the states. And so I would distinguish that on those grounds. Also, simply put, the Supreme Court announced in later...
So it doesn't, would you say it doesn't affect the states?
Correct. Your Heller addressed the federal government, but not the
Yeah,
states.
but in both Bruin and McDonald, the Supreme Court specifically held that the scope of the Second Amendment and the incorporation into the Due Process Clause under the 14th Amendment are identical. So why does the reference to federal government or states matter since they're identical?
Because of the new analysis, the historical analysis set out in Bruin, which was not addressed in Heller, that specifically laid out there must be a historical analog for the regulation. The Supreme Court has since then not addressed the issue of schools. In fact, in Bruin, the majority opinion referenced the Freedmen schools where teachers were armed, and it addresses that approvingly. So we can see that there's an analysis there that is yet to be done, and nevertheless, schools in particular, while the government side does try to analogize those to playgrounds, playgrounds and schools are not synonymous. One could say that they have the exact same relationship between playgrounds and cafeterias, right? Some cafeterias are in schools, some are not. Some playgrounds are in schools, some maybe, and it's hard to tell from this order, and I do believe this is one of the specific issues that Springer did not address, and that does not moot out this case, is the order is applied to playgrounds.
But they're
was not addressed.
playgrounds for kids. And from what your co-counsel was talking about before, kids don't, and we wouldn't want them to carry guns to protect themselves there. So that would be a rationale for keeping guns totally out of premises connected with schools. Would it not?
No, Your Honor.
You don't think it makes a difference that we're talking about kids here, and where kids play and are active?
Your Honor, this is not a case about whether people under the age of 18 can carry a firearm. This is really a case about whether people, including individuals such as my client, who's a concealed carry permit holder, may be barred from choosing to protect his family when he takes them to a playground. Schools also differ from playgrounds in that at schools, the school or the government is in loco parentis authority and responsibility over the students. And
Would that make a difference to how the playground's being used if it's for a school activity, for a football practice or something like that? Would that make a difference? Because then wouldn't you have to say that the school is in loco parentis for the athletes?
one could assume so, and in that case, one would have to look at historical analogs from 1791 or thereabout, and see that in those cases, the regulations were only on the students, not on faculty or visitors to the school, because that in loco parentis authority did not exist. And further, to have the playgrounds addressed, we don't even have a clear picture on where playground ends, meaning a McDonald's play place, a slide and swing set provided for in a private shopping center or in a mall. Would those count as a playground under this order? And those have nothing to do with schools. I'd like to reserve the rest of the time if that's all right, Your Honor.
Good morning, and may it please the court. I'm Janet Carter, representing defendants Appellees. This court does not have...
Let me
Excuse
ask you
me?
to start with. do you concede that these local ordinances are unconstitutional under the New Mexico Constitution?
Do I concede that the local ordinances are unconstitutional?
Yeah.
No. I'm here representing the defendants' appellees, not the local entities who are the ones responsible
But this is
for.
relevant to standing and redressability. Well, would you address redressability to start with, or are you arguing that they lack standing because they can't get redress?
Yes, they do lack standing because because they have not established redressability. And the reason for that is that each of the parks in which they wish to carry are also covered by a separate local ordinance. Now, as your question goes to, they do argue that those ordinances are unconstitutional under the state constitution, but I don't think it's appropriate for them to come to this court asking this court to answer a hypothetical question of state law when they've decided not to challenge those state ordinances that they say that they acknowledge separately prohibit their conduct in state
But there seems to be something
court.
inconsistent in the government's position there, because if they are constitutional, it's hard to see what the purpose of this emergency order is. The emergency order just duplicates what's already local law. And so you can't say it's necessary to have an emergency order at the same time as you're saying these local laws prohibit the same thing.
I think this is just the political judgment that is reserved to the Democratic branches of determining what is the best way to protect the people of Albuquerque and Bernalillo County, and the judgment was made that having a state-level order in place was important. I don't think any judgment was made in that separate ordinances were unconstitutional, but those ordinances are in place, and under this court's decision in Valdez, as well as the decisions from other circuits in cases like White and the exotic animals case from the Second Circuit, that means that there isn't redressability in this case.
Does
And
it
again,
matter that the penalties may be different? For example, hypothetically, let's say an ordinance says at Park X that if you are found carrying a firearm, you are subject to a $25 fine. The government's emergency order, hypothetically, says if you are found with a firearm at Park X, you are subject to imprisonment for up to 1 year, a fine of $100,000, and a lifetime ban on voting. Does it matter that the individual may have absolutely no concern about paying a $25 fine, may have no concern about being found in violation of the ordinance, but may very well object to the extraordinary penalties under my hypothetical emergency order?
So I don't want to fight the hypo, but I do want to start out by saying that I think the inverse is the case here. I think it's clear that the penalties for the unchallenged local ordinances are actually stricter than the governor's order. But even if that weren't the case, the law presumes that an order is enforceable, that a law that is in place will be enforced. That's the Consumer Data Association case. And these plaintiffs are here alleging that they are law-abiding individuals. I mean, they've declared that put that in their declarations. So I don't think that it is appropriate to say that they just intend to violate those laws at the same time they're saying that they're law-abiding individuals. So I think that's why there isn't redressability in this case. I also agree that the case is moot, or at least the appeal is moot, not the case. The appeal is moot as to the parks prohibition because of the separate injunction that is in place in Springer. It is not the case that that is limited to Mr. Springer. In fact, the defendants in that case asked the court to clarify that it was limited to Mr. Springer, and the court said no. It is clear that that does cover these plaintiffs, and that moots the relief that they're trying to seek. If I may speak to the merits quickly. In our view, there are at least 3 reasons why plaintiffs are not likely to succeed on the merits. Very briefly, there are well over 100 historical laws specifically prohibiting guns in parks. And those make clear that the governor's prohibition sits firmly within this nation's historical tradition of firearms regulation and within what Rahimi called the principles that underpin our regulatory tradition.
Assuming we consider 19th century regulations, correct?
Yes, so to be sure, the Supreme Court has not resolved this very complicated technical issue of whether 1791 or 1868 is the central focus
How
of
could
the
it
originalist.
possibly, now, you take the interesting position in your brief that we don't consider 1791, we only consider 1868, both for the Second Amendment and incorporation into the Due Process Clause. Other circuits have said you consider both 1791 and 1868. Now, I'm not questioning your position, but how can we consider both 1791 and 1868 if Bruin and McDonald said that the extent of the Second Amendment and the incorporation into the Due Process Clause are identical? In other words, if we have the exact same emergency order that is evaluated, say, under your view, in 1868, but we have a federal statute that does exactly the same thing, hypothetically, then we would not consider these historical analogs that you're asking us to consider for the 19th century, and we would be circumscribed by 1791, and it would be impossible then to harmonize into McDonald and Bruin, where we have the exact same scope for those two rights.
So I think these very difficult questions about the conflict really only, about the two different time periods, really only matter in cases where there is an actual conflict between the understanding at 1791 and the understanding at 1868. And that is absolutely not the case here. We have this enormous body of laws starting in 1858, and there is nothing at any point in history saying that anyone ever thought that it was unconstitutional to carry guns in parks. Now, Bruin was a very different situation because Bruin involved a challenge to a New York law that functioned as a complete prohibition on ordinary people with ordinary self-defense needs from carrying guns in public at all. And so what the Supreme Court said there was, we have found an overwhelming weight of other evidence from the 18th and 19th centuries that shows us that there was some right to carry outside the home. Here we don't have that. Now, plaintiffs say that they do have contrary evidence because they say that Boston Common and similar grazing areas from the founding were parks. And they say that because nobody has yet found any prohibitions on guns in places like Boston Common, that means prohibitions must have been unconstitutional. But they're wrong on both parts of that. First, Boston Common was not a park. The Second Circuit, the Ninth Circuit, district courts in Maryland and Virginia have all concluded that it was not a park. Parks emerged in the middle of the 19th century with Central Park as the paradigm example.
Is it a factual issue or a legal issue? Because it's really not either one. It's a historical issue, but how do we pigeonhole that into either a factual or legal issue? You argue that Boston Commons in 1791 was just there for grazing. They argue, point to historical sources that say that it was not only used for grazing for animals, but also for the source of recreation. You know, I'm not a historian, so how do I decide which one of you are right? Do I just look at your historical sources and decide, yeah, I think it was also used for recreation?
Well, I don't think it's a question of whether it might also have had some incidental use for recreation, just as, you know, children might use an empty lot to play in. That just because there is some recreation going on does not make a place a park. But to answer your question of whether it's a legal or a factual issue, I think it's best understood as a question of legislative fact, which is one where this court can look at more evidence than with respect to the kind of factual questions of adjudicative fact. And indeed, if you do look at the sources that the plaintiffs have put in, for example, the Beamish article and the Walls article, their own articles acknowledge that parks emerged in the middle of the 19th century. The Beamish article refers to Boston Common. The article is called Before Parks and refers to Boston Common as a pre-park landscape. So I think the only fair reading is that those earlier spaces were not parks. But even if you disagree with me on that, even if they were parks, I think the even more important point is that plaintiffs' argument is that the absence of legislation necessarily means unconstitutionality, and that is absolutely not the case. It is a premise of our federalist system that governments can regulate as they please, according to local needs and depending on policy choices within constitutional limits. It has never been the case that a government has to legislate up to the constitutional ceiling or else will lose the ability to legislate. That was what
Assuming
Justice
that's
Barrett...
correct, and assuming that the contemporary phenomenon of a park wasn't developed until the mid-19th century, don't we know from both Bruin and Rahimi that then the question is not whether in 1858 guns were allowed in parks, it's whether or not an historical analog, under their view, if we look at 1791, in 1791 there was an appropriate historical analog, and you argue that they were sensitive places, right? That parks were similar to schools, similar to places like that. So isn't that really the analysis, whether or not guns were typically allowed in 1791, if we use their historical benchmark for firearms?
Well, I think this question goes to the issue of looking at the whole span of history. And Rahimi instructs us to look for the principles that underpin our regulatory tradition. The principle here is the principle, as Justice Barrett put it in her concurring opinion in Rahimi, of the principle, she called it the sensitive places principle that limits the right to public carry. So that's the broad principle.
So if we look at 1791, what sensitive places did allow wholesale bans on firearms?
Well, Heller tells us that schools are
All right,
one.
schools, then, so in 1791, we had Virginia. We had some guy who wrote that he thought the common law in England allowed firearms, which was never enacted in North Carolina. So we've got Virginia. And then we have the fact that in 1791, the whole idea of banning firearms was limited to students. You haven't produced any historical evidence, I don't think, that schools historically in the 18th century banned firearms for anybody other than students, and that was under a theory of in loco parentis.
Well, as Your Honor said, I think this question is already resolved in Bonady, because when the Supreme Court said in Heller that its decision was casting no doubt on prohibitions on guns in schools and government buildings, it didn't say it was casting no doubt on prohibiting children from having guns in schools.
Well, did the Heller dicta actually say that firearms were completely banned in both government buildings and schools? I thought Heller's dicta only referred to the fact that schools and government buildings could be regarded as sensitive places that would facilitate regulations on the possession of firearms.
It said
I could be
that.
wrong.
I mean, I can read it. I have it here.
Okay.
Nothing in our opinion should be taken to cast doubt on, and then another phrase, laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings.
Okay.
So I think that's an absolutely unambiguous and universal prohibition. And as Your Honor said, when the question came up in Bonady of whether that is binding on this court, the court said, yes, it is. And it rested that solely on that historical proposition from Heller in this part of the opinion. It did not look at intermediate scrutiny in this part, and therefore nothing in Bruin, let alone Rahimi, disturbs it.
Let me ask a question, if I may. How do you respond to the argument by opposing counsel that the parks where there were prohibitions on firearms were special parks where you couldn't even use bad language? I mean, how do you respond to that factually?
I mean, these were all of the parks. The parks first emerged in the middle of the 19th century. Central Park was the first, then Prospect Park, then Fairmount Park. They spread all across the country, and these were parks for the people. They had rules, but all parks have rules. one of those rules was no carrying firearms in the park. They were absolute. They were not, as plaintiffs suggest, targeted specifically at a certain kind of conduct with respect to firearms. It was an absolute flat prohibition on carrying firearms. And that tradition reflects the long-standing principle, as Rahimi said, and as Justice Barrett said in her concurring opinion, that the people may choose to prohibit guns consistently with the Second Amendment in sensitive places. And this 19th century evidence shows that that parks are one of the places that the people decided were sensitive places where guns should be prohibited.
I interrupted you. If you have another point, you can state it very quickly. No?
No?
Very good.
Thank you very much.
Counsel. Would you change the time to 2 minutes, 15 seconds?
Yes, Your Honor. Thank you, Your Honor, and I have 5 points, so I'm going to try to talk fast. So first, with respect to bondity, I think that Bruin elaborated on Heller, and it said that it identified 3 specific government buildings, so it's certainly a refinement in that respect. And then it also said you can reason by analogy from those 3 locations.
Well, on the 3, though, it prefaced it, the signal EG.
Well,
not
okay,
IE.
there could be more, but it didn't. It could have just said government buildings. It said these
Fair.
3 specific,
Okay.
and then it said you have to reason by analogy, which means you have to do the how and the why. And so it just is not consistent with Heller and Bruin to say, okay, government building, that's it. So it undermined that. And with respect to the schools, the how and the why, it's clear it's because these it was students that were restricted, and the why was in loco parentis authority, and that certainly does not apply in parks and playgrounds. And certainly at a time of rising alleged criminality, the government, it's not like in school when you drop your child off and the government takes responsibility for the school's protection. Our clients are responsible for their own family's protection in these locations. The 1791, 1868, you're absolutely right, Your Honor. It has to be the same for both. The Supreme Court has held that. The only dispute is whether it's going to be 1791 for both or 1868 for both. And our submission is it makes much more sense. 1791, that's when the right was adopted. 1868 expanded the scope as to who the right applied, but it didn't change the right itself. With respect to Boston Common and its status at the founding, their own source says it was the rallying ground for all public meetings, parades, picnics, celebrations, and sports for the children, even before the Revolution. And the same source said that nearly all of the New England towns, a square generally consisting of from 5 to 10 acres, was laid out on public ground. So maybe there's a semantic, were these parks? I don't know, but they were places for public recreation. With respect to the founding era evidence, the 1786 Virginia law was one that you mentioned, and I think that law is actually very important. Bruin said it practically codified the common law, which means generally applicable law. And there were 2 parts of it. One said you could be barred from carrying in a terrifying manner in fairs and markets and other places. But the first part said that you can't bring guns into courts except for the judges and those assisting them. So what that shows is that there were certain places, yes, that were sensitive, but those were places where the government took on the burden of protection. Thank you.
Thank you. Cases submitted. Counsel are excused. Let's get ready for our next case, 25-1354, Estate of Charles Anthony Hurtado versus Smith. Ms. Orshon, when you're ready. What's this? We're going to need to wait a minute. There are people coming in. We'll wait till they get seated and close the door.
The bus must have just gotten here.
I hope they weren't here for the first case. I don't think these are the clients in spirit. I don't think these are the people who claim age discrimination. Jeez.
Maybe they boil them.
You all are very popular.
The bus just arrived.
Oh, my gosh. You have extra seats at council tables, so. Maybe they can help out. Maybe they go, yeah. Oh,
You met the Albanian judges?
yeah, that's right. That was yesterday. That's why we had the baklava.
I thought maybe that was who was coming in. Golly.
I don't think we're going to have enough seats for everyone. I've never seen this before. Have you ever had?
They knew you were presiding.
That's an attraction, I'm sure. Okay, I think we can start.
Good morning. May it please the court. My name is Liana Orshan, and along with my colleague David Lane at council table, we represent the plaintiff appellant, the state of Charles Hurtado, and our client, Bernie Hurtado, who is the personal representative of the state, is also here in the courtroom, along with other members of the Hurtado family. So to understand why the
Just to be clear, this is not all family that just
This
came
is
in.
not, as far as I know, this is not the whole family, but luckily we do have some family members in support.
Speak into the microphone.
Yes, is that better?
Twist it up a little. There you go.
How's that?
Good.
All right. So to understand why the district court erred in granting summary judgment to Dr. Smith in this case, in which he failed to provide the necessary treatment for Mr. Hurtado's abscess leading to Mr. Hurtado's death, it's important to break down the claim of deliberate indifference into its component parts.
What is the difference between deliberate indifference and negligence?
It is the state of mind.
It's what, I'm sorry?
It is the state of mind. So inadequate treatment is the basis for both a negligence claim and a deliberate indifference claim. In negligence, the state of mind requirement is negligence. In deliberate indifference, the state of mind requirement is knowledge or at least recklessness. So the difference is that for negligence, the doctor might not necessarily know or recklessly disregard that the wrong treatment is being provided, whereas in deliberate indifference, the doctor knows at the time that the inadequate care is provided that this is not the appropriate and necessary treatment to be providing.
So no matter how hard the person works to cure whatever the ill is, if he's negligent, that's also deliberate indifference. Is that what you're saying?
I'm saying that if someone is negligent, they're not necessarily aware that they are providing the incorrect care. Whereas in deliberate indifference, we must prove that the doctor knew at the time he was providing the incorrect care that it was the incorrect care, and that is exactly what we have in this case with Dr. Smith conceding that he knows that the treatment for an abscess is not the treatment that he provided. For an abscess, it needs to be completely drained, and discharge on oral antibiotics is not appropriate care.
Isn't that the whole point, though, that Dr. Smith thought it might be just a large mass, that it wasn't necessarily a walled-off abscess of pus, and so he did the needle aspiration, as a doctor might do, to find out whether or not his inclination was correct or whether or not an IND was required.
That is what Dr. Smith testified in this case. For the first time, he had made a statement that he did not diagnose an abscess, but because this is summary judgment, we must not evaluate the credibility of the witness and leave that to the jury. The objective evidence shows that a jury could easily find that Dr. Smith was aware, at the very least, and most likely did in fact diagnose that it was an abscess. That evidence includes Dr. Adon's notes at the time of the first visit. Dr. Adon was the ER physician that admitted and saw Mr. Hurtado initially. Dr. Adon writes twice. He had 2 separate discussions with Dr. Smith. The discussion that he had with Dr. Smith is after Dr. Adon noted that there's an abscess with osteomyelitis as shown by the CT results.
But Dr. Adon, isn't the problem for you, though, that Dr. Adon is actually the one that signed off on releasing Mr. Hurtado back to prison? And if he had done a needle aspiration and if his conditions continued to escalate, then he could have been brought back. But that wasn't Dr. Smith's fault. That, if anybody's fault, wasn't it Dr. Adon's for releasing him back to the prison?
I apologize. I believe it was both. They're both, as their conduct was objectionable, both of them. The reason that I believe, and the reason we sued Dr. Smith, I believe he is more culpable, is because Dr. Adon was acting on his recommendation to discharge Mr. Hurtado without any further procedures such as an incision and drainage.
Was acting on Dr. Smith's recommendation.
He was acting on Dr. Smith's recommendation, thank you. And the discharge notes show that Dr. Adon discharged Mr. Hurtado with a diagnosed abscess. And that is after Dr. Adon had 2 conversations with Dr. Smith.
Is there anything inherently problematic with beginning the treatment of an abscess with a needle aspiration?
The beginning might not necessarily be the problem. It's the failure to complete the drainage where Dr. Smith would have known that there is additional care that needs to be provided. Instead, he only got a tiny bit of pus, if that. He realized he didn't locate the pus pocket, and he didn't complete the drainage. By his own concession, that is not the appropriate and necessary care for an abscess. And again, he knew there was an abscess. That's the disputed fact. The objective evidence in the hospital notes, in the record, that Dr. Adon completed show that there was absolutely no diagnosis considered other than an abscess.
No, that's not quite correct. The doctor said at the time of his examination, there was no indication of a liquefied cavity. And, I mean, it seemed to me that they were really trying to figure out what was going on with this individual. And if that's going to be deliberate indifference, as opposed to making a mistake or not going quite far enough, what have we done to the profession?
Well, Your Honor, that is Dr. Smith's testimony
Well, that's
in his
testimony.
deposition.
He's the one that's being sued, and he's the one that was giving treatment. And he gave treatment over and over again and went back and rechecked and then finally went the way he went.
If we were to defer to Dr. Smith's testimony, which is exactly what the district court did, we would be making improper credibility determinations. If you look at the contemporaneous notes,
Well, the
only
distinction is still between deliberate indifference and negligence. You haven't answered that question yet.
Dr. Smith knew there was an abscess.
He thought there might be.
That is his testimony. That is a credibility determination. I am telling you that we disbelieve Dr. Smith. A jury could disbelieve Dr. Smith. If you look at the contemporaneous notes that were from the hospital record, there is absolutely no indication that Dr. Smith or anyone did not diagnose him with an abscess. And then if you look, I apologize.
Are there contemporaneous notes by Dr. Smith himself?
There are notes from Dr. Smith when Mr. Hurtado was admitted later that evening for the second time. Dr. Smith again saw Mr. Hurtado. Dr. Smith writes in those notes that he writes, and I'll tell you exactly what he writes because I think it's important. If I can turn this page. He writes under history of present illness that aspiration was attempted earlier today with no abscess cavity located. Under diagnostic imaging, he notes abscess of right perineal area. Under procedures, he notes attempted aspiration earlier today with no fluid returned. Under assessment, he states right perineal abscess with extension to ischial tuberosity. So in Dr. Smith's own notes from later that evening, there is no indication that he's changed his mind and now realizes it is an abscess, and that previously he had not diagnosed an abscess. There is
But what
only...
he's saying, just to make sure I have this, I'm understanding this correctly, what the notes are saying is now he determines there's a perineal abscess. He doesn't say that there was one earlier, but also he doesn't say that there wasn't, that he didn't think there was one earlier. Is that
Well, I
right?
believe we can infer that had he not diagnosed the abscess earlier, the earlier visit, and he's now diagnosing an abscess, that there would have been some indication that I previously saw a mass, but now I'm realizing it's an abscess. There is absolutely nothing in those notes that he changed his mind, that he's reaching a diagnosis that he didn't reach before, especially when he's talking about the history of the present illness, when he's talking about, and he knows that the abscess cavity wasn't located. He uses that term, no abscess cavity located.
Well,
So,
yes,
go ahead.
Was there some study, when you started going through his notes, you mentioned a reference to a study showing a perineal abscess. Was that study done during the first visit or the second visit?
That was the first visit, and that's the radiologist, the CT radiologist. The radiologist had an oral report to Dr. Adon saying that there was an abscess with osteomyelitis. That oral report was given to Dr. Adon before Dr. Adon had his discussion with Dr. Smith. Dr. Smith says he was guided by the CT findings when he was doing his needle aspiration. The CT findings weren't written up at that point. So the only CT findings he could be guided by was the oral report that the radiologist had given Dr. Adon. Dr. Adon must have passed it on to Dr. Smith. Dr. Adon describes those oral findings as the radiologist saying the CT shows an abscess with osteomyelitis. So yes, this is a link of inferences, and I really would appreciate you going with me on this link, but I do think it's very important not to take Dr. Smith's word for it that he did not locate the abscess cavity, which he says for the first time ever in this litigation.
When he says he did not locate a perineal abscess, does the record indicate how he looked for it? Did he just do one aspiration? Did he do multiple aspirations?
The hospital notes do not say. I believe it was just one aspiration, but it is not completely clear.
Is there any expert testimony on whether one aspiration is sufficient to determine whether there is an abscess pocket there?
Well, there is expert testimony that a needle aspiration is not the appropriate procedure once someone is aware that there's an abscess with osteomyelitis as shown by the CT. So that plaintiff's experts say that there was no reason to even attempt a needle aspiration at the time that Dr. Smith did once the CT results are told to him that this is an abscess with osteomyelitis. So once he does that, however, he needs to complete the drainage. If he's trying to drain the abscess, he did not do that, and he knows he did not do it. If he's trying to diagnose, as he says he is now, he never finished the diagnosis. There is no indication that there's any other diagnosis than abscess. So if he's really telling the truth that this was an attempt to diagnose, why do the medical records not reflect anything other than the diagnosis of an abscess? And if I may, I'd like to reserve the rest of my time for rebuttal. Thank you.
Good morning, Your Honors. Todd Drake on behalf of the appellee, Dr. Jerry Smith. Your Honors have touched right on, Judge Kelly, you're directly on point with this.
I'm sorry,
This-
can you speak, you
Sure
pull the
thing.
mic up.
He wants you to repeat that.
Sure thing. Judge Kelly, you're absolutely right. I'm happy to repeat that. The distinction here is what plaintiff has alleged and what their evidence has shown is a case of an alleged medical misdiagnosis, of alleged negligence. There is no evidence that supports a deliberate indifference claim. There is no evidence that Dr. Smith consciously disregarded some risk to Mr. Hurtado, chose not to in any way treat it, chose not essentially to ignore it. The argument from plaintiff is that the medical care that was provided, mind you, there's no dispute, Dr. Smith provided medical care. He provided a host of medical care, including a review of symptoms, speaking with the patient, obtaining a history, reviewing the labs, reviewing films, doing the needle aspiration, prescribing antibiotics, prescribing pain medication. What the appellant wants to argue in this case is that that's inadequate care. They have that throughout their complaint, they have that throughout their
I
brief.
see their argument a little differently. They're saying it's inadequate care if you know there's an abscess. And the argument is, one, that even though Dr. Smith testified that he didn't know there was an abscess, the jury can believe other evidence indicating he knew there was an abscess, such as the CT scan report and what the other physician had said.
Dr.
And
Adon.
second, that he, in fact, did testify that if there is a perineal abscess, he knew that the proper treatment is to drain it. So if that's the case, if there's no dispute that he knew what the proper care for a perineal abscess was, then the issue is, could the jury find that he knew there was a perineal abscess? And so why don't you address that factually?
Sure thing, Judge Hartz. I agree that's their argument. There is no evidence to support that argument. The CT report discusses, just as you said, Judge Bachrach, a mass. It doesn't discuss anything about an abscess. Dr.
Well, I thought
Smith,
there was the treating physician.
Dr.
before
Adon.
Dr. Smith, Dr.
Adon.
Adon. I thought his notes say that the CT scan oral report said an abscess.
That's the oral report he says that he received from the radiologist. That's correct. This goes back to,
And that was a contemporary note about what.
it was done after the note was done after this treatment was done after Mr. Hurtado had essentially left the facility. It's contemporaneous, but all this,
But it was before the second visit.
it was before the second visit. And to your point, Judge Hartz, that's exactly what happened. Dr. Smith testified that what he was looking at, he knew that there was a mass. He knew there was something there. That's the whole reason he did the needle aspiration. He was trying to diagnose what is going on with this patient. That's his testimony. It's appendix page 181 to 191. That's why he does the needle aspirations, try and look for, as Judge Kelly talked about, a liquefied cavity, essentially a walled-off abscess.
No, under his testimony, there's no liability. I think plaintiff admits that. I'm trying to focus on whether there's evidence that he knew, was told by an authoritative source that there was an abscess. And what we have is a contemporaneous note before the second visit by Dr. Adon saying he was told by the radiologist, I guess, that the CT scan showed an abscess. Now, you said two things here. The report of the CT scan just says mass. It doesn't say
That's correct.
abscess. How do you deal with the fact that a note indicates that the radiologist had told Dr. Adon, who then consulted with Dr. Smith, that there was a mass?
This is at the time of the second visit. This is when Mr. Hurtado is returned back to the facility. At that point, he had increased pain. He was hypotensive. Again, this is, Dr. Adon he actually consults with Dr. Smith again at this second visit. And that's when the decision is made to admit. That's when Dr. Smith is thinking, okay, this is a pararectal abscess. There is concern here for something beyond just, trying to diagnose what's going on.
I'm trying to get the chronology right then. My understanding from opposing counsel was that Dr. Adon's note indicates during the first visit, he was told that the CT scan showed an abscess. And that's one fact alleged. The other important fact is that Dr. Adon consulted with Dr. Smith, and one would think, at least I think it's a reasonable inference, that Dr. Adon would report to Dr. Smith what he'd been told about the CT scan.
It's really the distinction, Your Honor, between, there's no real question that there is an abscess there. That's not the question. The question is, was this a walled-off abscess that had this liquefaction? Was there a liquefied cavity? Because that is what then leads to the additional treatment, the IND, the
So an abscess, okay, then I misunderstood the medical testimony. I thought if it was an abscess, you have to drain it.
No,
I'm sorry. And perhaps it's a walled-off abscess, then it's not necessary to drain the walled-off abscess?
That's exactly what Dr. Smith explained in his testimony. That's exactly what he's looking for. He said, this idea that he somehow conceded that if this was an abscess and he knew he was doing something wrong, that's just not correct. Plaintiff's counsel was asking him questions related to his expert report, the Dr. Schechter's report. Do you agree with Dr. Schechter on this? What Dr. Smith said was that, no, I don't agree with Dr. Schechter. In fact, this opinion about that I needed to somehow, the needle aspiration failed to go ahead and totally drain this abscess, that's not even pertinent to this case, because what I am trying to do is I am trying to diagnose, does he have a liquefied cavity? Does he have something that requires additional treatment, the incision and drainage? Dr. Smith testified, he said, had there been liquefied cavity, had I found that, I would have considered other treatment. I would have gone a different direction, but that did not exist.
Did plaintiff's experts say even if it was walled off, it should be drained?
Well, that's the key, is if it's walled off, it's drained. What plaintiff's experts are suggesting is that the moment anyone comes in with any sign of infection or an abscess like this, you need to immediately go to incision and drainage. That is a dispute of the standard of care. That really is the crux of this. They say this is the...
Well, that would make Dr. Smith liable for negligence.
Exactly.
But even though an expert witness may testify that Dr. Smith should have done this immediately, Dr. Smith did not concede that that was his knowledge at the time.
Exactly right. He didn't have that knowledge. In fact, it wasn't they just didn't have that knowledge. He testified it was exactly opposite to that. What he found was there was no liquefied cavity.
I mean, knowledge of the proper treatment.
Right. He acknowledged knowledge of the proper treatment would be, had I found a liquefied cavity, a walled-off abscess, then yes, I would have considered an IND. I would have considered having him admitted. That's why when he returns later, and now you've got the note in the chart, okay, now we've got some concern that this is a walled-off. Now they admit him. Now they have him in. It's the reason the next morning surgery was done, to drain that abscess. This is all part of the physician's workup. They're looking at what's going on with this patient. Why is he having these symptoms? That's exactly what Dr. Smith is doing, is trying to diagnose those symptoms. He didn't say, oh, I knew that this was an abscess and I knew that my treatment of that was not appropriate to do it. That's just not supported by it. It gets back to, Your Honors, what the plaintiff has demonstrated, and Ms. Orshon talked about this, they have to show some culpable state of mind. Their experts agree. They cannot say that Dr. Smith was doing anything to try and harm this patient. They both testify. They agree they cannot speak to Dr. Smith's state of mind. They can't say what he was thinking or that he was somehow consciously disregarding a risk.
Their theory, if it's factually based, tell me if there's something wrong with their theory. Their theory is that there's evidence that Dr. Smith knew there was an abscess. And second, that Dr. Smith admitted that if there was an abscess, the proper treatment is to drain it surgically, however, immediately, not just aspirate.
I agree that's their argument. The
Yes,
record
and if-
evidence
if
doesn't
that were-
support
If those
that.
facts were true, that there's evidence to support that Dr. Smith knew there was an abscess, and that Dr. Smith admitted that if there's an abscess, he has to drain it. If that's true, would that not show deliberate indifference?
Only if it was that he knew that this posed a risk to Mr. Hurtado and that he consciously chose to disregard that risk. Again, what you're talking about are different forms of treatment of a medical condition. It's a difference of opinion as to what is the proper treatment of the patient, and that's what they're challenging.
Not the way I phrased it. The way I phrased it, there's no dispute about Dr. Smith's opinion. She's asserting two things. One is that Dr. Smith agreed that in X circumstance, the proper treatment is surgical. And second, that the circumstance leading to that requirement of treatment was, there's evidence that Dr. Smith knew that was the situation at the time. Now, so I want to try to make sure where you two are differing.
Sure.
Do you agree that if she's factually correct in her assertions, that would support a claim of deliberate indifference?
No, because you're still discussing a choice of treatments. This court has recognized since Self versus Crum that a doctor's decisions about what forms of diagnostic
absolutely
techniques
right.
or treatments should be required. That's what,
You're absolutely right on that principle. The question is the facts here. And she says that Dr. Smith acknowledged in his testimony that if he knew there was an abscess, he should have performed the surgery sooner. Do you disagree with that?
I disagree that that's what he said in his
Okay.
deposition.
I
disagree
In what way
that-
is that wrong?
The evidence is that Dr. Smith, again, he's responding to these questions based on the plaintiff's expert report. Do you agree? And he says, no, I don't agree. In fact, he says, I don't think that's even pertinent to this case because what you're discussing over here, what Dr. Schechter, the plaintiff's expert, is discussing, is not the facts of this case. It's in a hypothetical world, sure, if Mr. Hurtado had come in with a walled-off abscess and there's liquefied cavity and Dr. Smith says, I see that that's a walled off, there's a liquefied cavity there. I know that the treatment for that is incision and drainage and then chose not to do that, that could support a deliberate indifference claim. That's not the evidence in this case. It's not even
Because
close to the
there's no
evidence.
evidence that he knew it was a walled-off abscess.
That's right. First of all, he specifically said, I found that there was no liquefied cavity here that required it. So that's the first step of
And
it.
a jury could not disbelieve him based on other evidence in the medical record.
The jury, again, I agree, this is not a credibility fight over Dr. Smith's deposition. That's not what the district court did here. He didn't rely on Dr. Smith's deposition testimony. What he really relied on, the district court relied on more than anything, was the expert report from plaintiff of Dr. Harris, who said, that's right, reasonable physicians can disagree about how to treat this condition. What Dr. Smith did, his experts say that is appropriate treatment. Dr. Harris said, that's right, those are reasonable physicians, they can disagree on this, and that's exactly the point. Then it is not patently unreasonable, the care that was provided. There is no evidence that he knew of this and consciously chose to disregard that risk. So that's really the issue. Could a jury believe that Dr. Smith was not credible? Sure, but that's not the basis of the summary judgment. So this idea of, she talked about this link of inferences that need to be made. 10th Circuit law is clear. You have to have evidence. You can't have speculation. You can't ask, okay, come along with me on this idea that Dr. Smith is somehow not telling the truth, that he knows this, that he knows his treatment's inappropriate, that he knows the proper treatment needs to be done, and he chooses not to do it, all because you just don't believe Dr. Smith.
Could a fact finder reasonably infer, viewing the evidence favorably to the estate of Hurtado, that when Dr. Smith did the needle aspiration and he looks and there's a pus that he sees, he says later in his deposition that it wasn't walled off. But why is it an unreasonable inference for a fact finder to infer that given the escalation, what happened within a 24-hour period, what he was looking at, he must have seen that the pus was surrounded by tissue, that it was a liquefied cavity, notwithstanding what he later denied, based on the increase of pus that accumulates within a very short period of time?
It would still only support a medical negligence claim, Judge Bachrach. What they're essentially saying is that he somehow should have known that this patient would deteriorate over time, that there was enough evidence there for him at the time to say, I need to go ahead and proceed to an incision and drainage. I need to admit this patient. I can't just prescribe him oral antibiotics. We can't send him back to the jail. All those I agree, that might support a negligence claim. That goes directly to it, and that's where their experts talked about the standard treatment. The standard care of treatment is incision and drainage. That's medical negligence. That's what they're arguing in this case. They do not argue. Their experts don't provide any evidence. There is no evidence in this record that Dr. Smith knew that this presented a risk to Mr. Hurtado, that this was some walled-off abscess, that he consciously disregarded that risk. They're asking you to make a set of inferences based on argument. Their expert testimony doesn't support it. Dr. Smith's deposition testimony doesn't support it. So based on that, Your Honors, we're going to ask that this court affirm summary judgment in favor of Dr. Smith.
Thank you, counsel. You have her 3.5 minutes.
Why?
Because he took over time. Pardon?
You gave him extra time.
Oh. I'll be more rigid.
Steve?
So we absolutely disagree that this is not a credibility fight. And in fact, that is the main failing of the district court order, that the district court did not even recognize that this is a credibility fight between Dr. Smith and the objective evidence, the circumstantial evidence that shows, in fact, Dr. Smith
But
knew.
that still is not deliberate indifference. You can be stupid, but you're not deliberately indifferent. And he said specifically, time after time, I did not attempt to manage it by needle aspiration. I attempted to diagnose. And that's what he was doing. And he initially said that he did not find a liquefied pocket at that first point. So I just don't understand where we're going with this, because the absolute liability, if you make a wrong diagnosis, you're deliberately indifferent. That cannot be the rule.
He
All
didn't,
my kids are doctors. It'd be disaster.
he didn't make a wrong diagnosis as a mistake. Whoops, I made a wrong diagnosis, like in self. In self, the symptoms would support a wide variety of different types of conditions. The doctor made a decision at the time that seemed reasonable and consistent with the symptoms, and there's absolutely no evidence in self that he did know it was in fact endocarditis. In this case, the objective evidence shows that Dr. Smith is not telling the truth. So there is no reason at summary judgment we should just go ahead and believe Dr. Smith's
Why didn't you file a
subsequent
negligence?
testimony.
Why didn't you file a negligence, a malpractice action here?
It's a public hospital, so it was.
I'm sorry?
He's a public employee, so he's immune under the CJIA. So initially we did, but we dismissed it once we had conclusive evidence that he was a public employee. I do want to make very clear that Dr. Smith said abscesses cannot be fully drained by needle. Antibiotics are inadequate to treat if there's a known liquefied pocket. Antibiotics are commonly considered inadequate to treat if there is a known pocket of pus. And then this is his deposition where he's denying that he identified that there was a pocket of pus, that he knew that there was a pocket of pus. But he had the CT findings. He had the oral report from this radiologist via Dr. Adon. That said,
Just-
this is a
counsel,
mass
just a minute,
with us.
Just
Sorry?
a minute. The CT scan did not definitively state what you're suggesting it stated.
That was the recorded CT scan, which was recorded later. It was not in the notes at the time that Dr. Smith performed the aspiration. He had to rely on the oral report. The oral report is that there was an abscess with osteomyelitis. The fact that there was an abscess with osteomyelitis per the CT findings means that he knew there was an abscess. He knew the risk of not fully draining the abscess because it's osteomyelitis, a very dangerous bone infection that in fact can be fatal. And if you look at Schechter's report, he explains this whole timing of the CT report and why there is absolutely no way that Dr. Smith could have relied on the written CT report at the time. And I believe my time is up, but
Your
again, I
time
want
is
to
up.
make very clear, this
you.
is a credibility dispute. Thank you very
You
much.
made that clear. Oh, whoops.
I just wanted to ask you just something, just to make sure that I understand it. Is your assumption or position that an abscess is by definition walled off?
I believe it's actually not. It is walled off. It's a liquid cavity.
Surrounded by tissue?
Yes, so it's not the needle aspiration that would have revealed to Dr. Smith necessarily that there was an abscess. It's the other findings. It's the CT oral report
Okay.
that there was an abscess with osteomyelitis.
That fully answers my question. Thank you so much.
Thank you.
Thank you, counsel. Case is submitted, counsel are excused.
This is why all the clarity for this new
Oh, they're all leaving. But look, everybody's leaving.
They're all leaving?
Yes, but we're losing our audience.
It's amazing. I thought it was a spirit case.
Do you know what was going on? Was it? I think they must have been relatives. They must have been relatives of the.
Of who? Dr. Smith?
You're right. They're all your children who are doctors.
Wait until everybody.
Yeah. So they're still exiting. Well, maybe my law clerks can tell me later what this group was. Maybe they're looking at one, I think they're looking at one case in each courtroom and then will rate us. Looks like we're about ready. Okay, so we'll now take number 23-3126, Raymond versus Spirit AeroSystems Holdings. Mr. Castor?
Thank you, Your Honor. Jim Castor for the appellants. May it please the court. I'd like to reserve 3 minutes for rebuttal. The calibration sessions that occurred just before the layoff that is at issue in this case are described by 4 courageous first-line managers who testified, volume 7, starting at page 53 of appellant's appendix. They're brought into a room to do this calibration. HR owns the calibration meeting. They're present. Upper-level management above them are also present. They're not allowed to take any notes with them. No notes. No cell phones, no recordings of what happens in that room. We'll go outside of the room. They meet again and again. They're told before the first meeting by David Walker, who's the chief technology officer, that young people are the future of the company, that Boeing people are old DNA.
And the only evidence of Mr. Walker's statement is through Deborah Miller, right?
That's correct.
Right.
Who starts at page 70, Your Honor. Ms. Miller testifies that they're told to protect new hires, the fresh young faces in the company, to downgrade the older, sicker employees, and those who refuse, and she testifies about Ellen O., who specifically objects to this, she is terminated. She's fired. Those who refuse are suspended, terminated, or forced out. The district court disregarded Mr. Walker's statement that young people are the future of the company. In this an age case,
Is there any evidence that Mr. Walker had anything to do with the reduction in force in July?
well, what the evidence demonstrates in the 2018 order that the district court entered, the district court talks about the same upper-level managers orchestrating the plan, which was created in October of 2012. Do I have specific evidence that Mr. Walker was involved? What the district court found was that the same upper-level managers executed all of the steps in 11 different steps.
Well, but aren't you conflating things? Because in 2012, originally, and I think in October, they were conceiving of a voluntary retirement plan, which is perfectly permissible.
It may be permissible, Your Honor, when you're identifying a protected class, like long-tenured employees.
But you certainly have never argued, I don't think, that 623 D2T-BII would prevent them from singling out older employees, 62 and over, for a voluntary retirement.
We don't contest that.
Okay,
But
and so
Mr.
go ahead.
No, but Mr. Walker's instruction to the managers is certainly involvement, Your Honor. He instructs the managers who are conducting this reduction in force grading that they are to remember that young people are the future of the company. Now, these meetings happen again and again, according to Ms. Miller's testimony. They have entered into a rigorous calibration where HR and upper management needs to agree on the calibration ratings. And the people who don't go along are pressured out of the company. That is involvement. When he tells them, this is what you need to do when you're doing this grading for the calibration. Remember, young people are the future of the company.
Well, isn't it a problem, though? Because Deborah Miller, your source for what David Walker said, specifically says that the pressure that she got from HR, she was specifically asked, do you know whether or not these were the people, the higher level authorities within HR within the company? And she said, no, I really don't know whether or not it was, just the one of the 300 managers that, or one of the HR people that told me what they thought. So Deborah Miller couldn't isolate the pressure that she received to say that this was a widespread pattern of practice.
Well, what we do know, she testified about what she knew happened in that room. She testified about meetings happening again and again. It's a reasonable inference that David Walker, as the chief technology officer of the company, when he speaks that young people are the future of the company, is speaking for the company. He is a chief officer of the company. So he speaks for the company.
Isn't that a tautology?
Pardon me?
Isn't that a tautology to say young people are the future? Young people are the future of this court, but they haven't kicked me out.
In an age, certainly, Your Honor. I mean, is it true that young people will certainly be sitting in all of our positions at some point in time? Of course. But in an age case, when you're told between measuring X or Y, and you're told specifically by someone speaking for the company that young people are the future of the company, that is an admission. That is direct evidence of age discrimination. And that is then ignored by the court as essentially a truism.
Well, they were specifically told not to consider age, weren't they?
That was one of many things they were
Yeah,
told.
and
They were also told.
So and I think you're taking issue that the first-line managers wanted to keep some XYZ people. But when it went up one level, they said, no, we're not going to do it that way. What's wrong with that? If the first-line manager's buddies with Judge Harris, and he wants to keep him on because he's a good guy and he does pretty good stuff, but the next level up says, he's not really up to it. Is that age discrimination?
It may be if the
So that
reason why the other person is saying the next
Well, that's why they
person
set up a hierarchy.
is because of age. Certainly, these are credibility determinations for the jury to make. When an officer of the company who speaks for the company as the company's direct sponsor, someone who makes an admission for the company says young people are the future of the company, that is a direct admission. That is direct evidence in an age case. Now, what I would also say, there are two orders at issue in this case, the 2018 order and the 2023 order. They're here on summary judgment.
Is
So
what,
the-
I'm sorry?
They're here on
Oh,
summary
yeah.
judgment, both of them. So the standard of review is de novo, with us receiving the benefit of inferences from the record, which goes back to the questions we're talking about now. Our position is the district court weighed the evidence and actually drew inferences in favor of Spirit on significant points like this one that we were just talking about.
Well, how does our Apsley case fit into this?
Well, that's an interesting, thank you for that question, Your Honor. Apsley is a longer decision, and so I picked out one sentence that I think actually supports our position in this case. Unlike the cases cited by the plaintiffs, I'm reading from Apsley now, there is no evidence that upper-level management viewed older workers as less capable or younger workers more favorably, or believed that older workers needed to be replaced by younger ones. That's exactly what we have here.
Well, you mean by saying the future is with the young people, that's automatically bad?
Is it automatically bad? I
Can't
mean, you
say
can
that.
argue about what that
You
means.
can't say that, is what you're telling us.
Well, it would be impermissible to, well, it would be relevant evidence, let me say that, for me to say, well, I think that this company would be better served by having all males. Does that indicate, if I'm speaking on behalf of the company, does that indicate automatically there's liability? It's an admission.
What
It's
if
a
you're
direct
saying
statement.
that in encouraging a voluntary retirement plan? To entice people that are older to leave the company?
Not a RIF.
Yeah, not a RIF. Why is that impermissible?
Well, let me just say this. The actual document where this comes from is drafted in October of 2012. It's a series of 11 different cost-down measures, which includes a voluntary retirement program. There's a significant intervening event between October of 2012 and the actual layoff in July of 2013. Because Jeffrey Turner is the CEO in October of 2012, he is opposed to layoffs, flatly opposed. And there's no dispute in the evidence about that. Then Mr. Lawson starts on April 6th of 2013, and he is totally in support of layoffs and dogged about the headcount reduction. So it's a reasonable inference that this idea of replacing long-tenured employees with new hires evolves between October of 2012 and July of 2013. That is a very reasonable inference from this evidence, given the fact that Mr. Lawson comes on board and he is dogged on headcount reduction and supports the layoff. What we also have in this case, I'm sorry, Your Honor.
I think you're about to answer my question. Go ahead.
What we also have in this case is they're hiring while they're firing. So this isn't really the same as what you think of as a reduction in force. They have 50 salary job offers ready at the time of the layoff in July of 2013. They have almost 500 new jobs, hourly jobs, they say, ready by the October job fair. And the evidence in this case is that they hired 1,766 people between 2013 and February of 2015. That's clear evidence in this case. And so this isn't really a reduction in force, it's a replacement in force.
Well, how many people retired, took the retirement option?
There was actually a retirement option in September of 2013. It wasn't offered until then. We didn't get data about how many people were involved in that and how that implicates the rest of this. So I can't answer that question. We didn't get discovery on that issue.
To try to replace the less valuable employees?
Well, what the evidence,
That's
I'm
what
sorry.
Spirit is saying. They want to get the 10 most dispensable, 10% most dispensable employees.
In
What's wrong with replacing them with people they think will be more productive?
That's certainly a question of fact for the jury. Did they focus on the bottom 10%, or did they force people to downgrade the older employees, which is what Ms. Miller testified was happening? And other managers, Smaltz, Fuller, the other managers testified to the same. I'm going to, into my rebuttal
Well,
time.
you haven't addressed the statistical evidence at all.
Well, I haven't addressed the statistical evidence, Your Honor, and what specific questions does the
Well-
court have?
The district judge went into some detail in analyzing that evidence. And I don't think your briefing really challenged the reasoning there. It made allegations, but you're supposed to, the appellant is supposed to show how the district court made a mistake.
Well,
And I didn't see, this is complicated stuff, but I didn't see any attempt really to explain why the district court's analysis of the statistical evidence was wrong. The reasons for rejecting some evidence, for the reasons for thinking this evidence isn't very probative and all. Do you have something to say about that?
certainly, Your Honor, it's a battle of the experts. Once the court, this is what I would say about the statistical evidence. The evidence demonstrates through Lance Kaufman that people who are older were twice as likely to be terminated as
the
those who
judge-
were younger.
And the judge didn't credit that.
Once-
And so you have to explain why the judge was wrong to discredit that, because the analysis didn't include things such as, what's the term? Their versatility of that wasn't even included in the analysis. I would have expected some argument about how the district court's treatment of the statistical evidence was wrong. It's not enough to say, well, there was a contrary expert.
Well, Your Honor, there's two basic differences between the experts. And one is about the population that they studied, Dr. White choosing the smaller SPIA population. And the other is about he chose the SPIA population specifically within, so Dr. White's analysis, what we're saying is those and Dr. White also divides the analysis into 151 pools, basically subscribing to the notion of decentralized decision-making. That
You're not responding to my question. The question isn't whether Dr. White's analysis was any good. The question is whether the district court was correct to give very little weight to your experts' statements, and he showed various things that he found were flaws, and I would have liked to have heard how the district court erred in its analysis of those things, and I don't see that. It's just, the briefs just say, well, we had contrary experts. But the judge, particularly with expert testimony, the judge has a gatekeeping role. And here he didn't go so far as to say this wasn't admissible under Daubert. He left that unsaid, unresolved, but said it's not probative of what they're trying to establish in this case. And
the versatility and criticality are, we think, subjective standards. With respect to the performance management rating, they're supposed to go into that. So the court, what Dr. Kaufman did is demonstrated that between 2010 and 2013, older workers were twice as likely to be downgraded.
right.
And twice as
You're not responding, but did you have a question, Judge Baker?
Well, I just wanted to ask you about that very point. So you're saying that from the 2010 retention exercise versus the 2013 retention exercise had disparate results. Older workers were twice as likely to have a C rating in 2013 versus 2010. But as you've discussed earlier, the elephant in the room is the 2011 and 2012 recalibration of the way that they were evaluating. And I mean, you find fault in that, but I don't think anybody at either council table is going to dispute that the whole criteria, the whole rate-making exercise in 2010 and 2013 are going to be wildly different. So I don't understand why Dr. Kaufman's comparison has anything to do with whether or not the RIF was targeting older people, because you're not comparing apples and apples.
Well, Your Honor, between the critical dates that we're talking about, what Dr. Kaufman demonstrated is that older workers under the same rubric, under the new rubric, were more likely to be downgraded than younger workers, which we think is probative. Once the court allows the evidence and doesn't exclude the evidence, I think those kinds of determinations, population choice and pooling, for example, are questions of fact for the jury.
Thank you.
Thank you.
When I asked my question 2 minutes left, I saw you about to ask the question too, so I appreciate it.
Good morning, Your Honors. I'm Stephen Moore, representing the appellees here. And this case is about how the district court reviewed the undisputed material facts in the light most favorable to the plaintiffs, but ignored unsubstantiated allegations, statements of counsel, speculation, and conjecture. Only reasonable inferences were accepted by the district court. The district court here actually drilled down to see, there's a statement made in the brief, drill down and notice the record didn't support certain allegations, and statement of counsels are just not evidence on summary judgment. And the 10th Circuit has said evidence on summary judgment has to be reviewed in the context when summary judgment is being considered. That's the O'Shea versus Yellow Tech case. And as it relates to statistics, the 10th Circuit in Apsley versus Boeing Company and Spirit AeroSystems says statistics must always be evaluated in the context of all the surrounding facts and circumstances. Now, before I go any further, I want to explain, we are dealing with a pattern or practice theory. It's critical. It's different than a single plaintiff theory. That would be under McDonnell Douglas. Pattern or practice means the standard operating procedure was discrimination. Looking at an isolated or sporadic situation is not enough. The court must look to see, and that's what the district judge did here, was there this continuous pattern or practice of this alleged discrimination? The answer was no. And I submit, Your Honors, that's where the rubber meets the road in this case. Now, there are decisions made by hundreds of different first-level Spirit managers. The managers exercise discretion while applying facially neutral standards.
Well, her testimony was, after all, she did testify that she believed that she was being pressured by HR to downgrade older employees. She then couples that with what David Walker said, and David Walker did speak, as the chief technology officer, that the future of the company was newer employees. Viewing the evidence favorably to the plaintiff, why can't we reasonably infer that there was a pattern or practice to downgrade older employees when they were deciding who was going to get a C rating as opposed to an A or B?
Your Honor, this is where the district court did drill down on those kind of statements of counsel.
That wasn't a statement of counsel. That was a statement in a deposition by Deborah Miller.
Okay, let me start with Mr. Walker, and then I'll address Ms. Murray. There's no evidence that Mr. Walker was involved in any decision to conduct a reduction in force. How the reduction...
But can we reasonably infer that he was, that he had a role to play in the performance, in the performance rating in 2012? Because the performance ratings in 2012, it directly went into the combination of versatility and criticality in deciding who was going to be a C get a C rating in the retention exercise?
The criteria for the retention ranking was a three-prong. You had performance, versatility, and criticality. So performance is factually distinct from the other two. But there's no evidence that he was involved in rating or selecting any employees or directing anyone in that regard. And the Doe versus University of Denver case would view this, the 10th Circuit case, as an isolated remark. And his statements.
It's an isolated remark, even if he made that statement in the calibration exercises?
Well, the allegation is not that he made it in calibration, but as I understand, performance, which is not the same. But he is not commenting on the reduction in force and the decision-making there.
I'm getting confused here. If he had a role in how employees are, how their performance is evaluated, and that was, and there was an ageist bias in that regard, that might well show up eventually in how you determine who's going to be RIF'd. So if he had a role in evaluating performance and he's telling people how to evaluate performance, would that not be a pattern, a practice, a high-level decision by Spirit?
There's no evidence in the record that a chief technology officer had any say with the hundreds of people who were involved at many different divisions.
What was the nature of this event where he allegedly made these remarks? I thought it was a performance evaluation meeting.
As I understand, Deborah Miller testified about this, but the record doesn't really reveal where it occurred or how or to whom. But let me just point out, even if a statement was made, the 10th Circuit line of authority dealing with stray, isolated comments has to be by a decision maker. There's no evidence that Mr. Walker was deciding anything, reviewing any performance of anyone as it relates to this case with the reduction in force. And there has to be a causal connection on top of that to the reduction in force here, the selection of older workers. The evidence is just lacking in that area.
Well,
And
if there's no testimony about the context in which David Walker made the statement in front of Deborah Miller, and if Deborah Miller didn't testify not only to that statement, but that she was being pressured by HR to downgrade older employees and put them in the C category, how do you say that there's not a reasonable inference to be made that this could have been made in the context of calibration exercises, that the whole point was to train these 300 managers on how to exercise these PM ratings, on who to put in the lower 10%, the C ratings? Doesn't your problem, doesn't the sort of the vacuous nature of the context countenance in favor of denying the summary judgment motion?
No, Your Honor. As I said earlier, this is a pattern or practice case. There has to be a showing that all these hundreds of decision makers all were motivated to discriminate on the basis
What if
of
the
age.
CEO, what if Mr. Lawson had sat there, or Mr. Turner had sat there with the 300 managers and said, I want you to downgrade older employees and, all things being equal, put them in the C rating. And also, keep in mind that the future of the company are the newer employees, not the old men and women. Now, would there be evidence to support a pattern of practice, an ageist pattern of practice?
Your Honor, there's no evidence that either Mr. Turner or Lawson ever said such a thing. But let
Would
me
you
also.
agree that if they did, that would be evidence?
If they directed the first-line supervisors to engage in discrimination, yes, but that does not exist in this case. The
Well,
opposite
now
exists.
let's say you substitute, Jeffrey Turner and you put in David Walker, Chief Technology Officer. Why is the result different?
Well, like I said, there's no evidence to whom he was referring to, how many people was he referring to, who even heard him.
Wait. I thought, maybe I misunderstood. I thought this alleged statement by Mr. Miller, or not Mr., by the
Mr.
chief,
Walker.
yeah, was to 300 managers.
No, I don't believe that's accurate. It's not in the record.
There's no record of when he made or to
No.
whom they made that statement.
That's correct. And Your Honor, I would like to point out the Apsley, Boeing, and Spirit case from the 10th Circuit in 2012 addresses comments that were found to be stray and isolated. And the court basically says a mere handful of statements in the face of hundreds of decisions and performance ratings, retention rankings, and layoff selections is just insufficient to establish a pattern or practice. I mean, I'll give you an example. The latest pattern or practice case to come before the United States Supreme Court was Walmart versus Dukes. It was a gender discrimination case. It was a Rule 23 case. But there, the U.S. Supreme Court, in addressing commonality, it did address the pattern or practice paradigm.
But it was
said that-
commonality under Rule 23.
Yes, I
not
understand that.
pattern or practice under the
I-
ADEA.
But the court did address the elements of pattern or practice. I'm just bringing this up as an example.
Okay.
The U.S. Supreme Court found there was just no evidence that the decision makers, the frontline supervisors, in that case dealing with pay and promotions, were somehow guided by an edict or something else that required them to always exercise their discretion against women. So taking that by analogy to our case, there is no evidence here whatsoever that the first line managers were guided by some edict or policy or something else that required them to exercise discretion against older workers. Now, keep in mind, Dr. White, who was the statistician, did a traditional analysis where he measures the expected number of how many people over 40 should have been laid off. And there was a deviation of 8 people, and that was found to be statistically insignificant. There was also, and by the way, uncontroverted, the other side never did an analysis of that type to refute that number. The average age did not change materially.
Well, isn't that in part because the number of people riffed was such a small percentage of the total workforce? So you could have great disparities in who's riffed without changing the average age makeup of the workforce.
Well, in looking at the way the reduction force was carried out, even though some of these plaintiffs are crying foul that they were selected for the reduction force, their coworkers who were much older were kept on in many instances. But the age before and after is something the 10th Circuit has looked at before. For example, in Apsley, it was an important issue. I mean, if they're alleging age discrimination with the intent to get rid of older workers, well, the evidence, at least on the average age front, doesn't support that. Let me just address briefly, there was a comment about new hires after reduction force. Those were for hourly positions. The plaintiffs in this case were salaried employees, not managers, but salaried employees. The positions that they're saying they were hiring for in 2013 were hourly employees, a whole different job category.
Were they for the Wichita plant, or was that company?
They included for Wichita, and that's where the job fair was.
So I know it included it included Wichita. I just didn't know if it included Tulsa.
Do you mean the openings or the
The statistics that you're rebutting?
they were just simply for Wichita?
For which, okay, thanks.
Yes. And so this reference to, well, the company's hiring afterwards, they're hiring for hourly positions that are not part of the positions that were eliminated. And the district judge did say that there was no evidence that anyone was hired for those positions where the employees were laid off. I think that's an important fact. And just real briefly on the statistics, there was no battle of the experts here. The judge accepted as true many of the things the plaintiff's experts said, but they just didn't address what was needed to find a pattern or practice of discrimination. Many of the studies by both experts didn't analyze the correct population. While it may have been mathematically correct, their numbers, it didn't answer or lend any support for a pattern or practice of discrimination. And the district judge, he really did go through the statistical issues and explained his rationale. It is supported by the Apsley case. I see that I've gone over, but the Apsley case found that higher standard deviations were not sufficient for a pattern or practice case because there was no evidence of any sort of pattern or practice with other evidence. We have the same scenario here. Our district judge said 2 and 3 standard deviations are not enough, especially when you don't, when these policies are facially neutral, workers are being trained to not use age in their decision-making.
When you say there was no battle of the experts here, I thought the district court discounted a fair amount of plaintiffs' experts' testimony as being poor science, perhaps, because, for example, in performing their analysis, the experts didn't consider the fact that versatility was a factor in hiring, things like that. You don't read the district court as having done that?
No, I mean, the court did say that Dr. Kaufman didn't control for versatility and criticality, and that was factors being measured for retention ranking. He did point that out. But let me give you an example, like Dr. Bardwell,
Go ahead.
he says, he's related to the hiring claim. He says, if you're a former employee, the chances of you being employed are less than if you were an external hire or an existing employee seeking a promotion. Okay, the judge accepted that as true, but that didn't address an age issue. Okay, the correct analysis would have been to look at the applicant pool, external, internal, people seeking promotions, people formerly laid off or fired for other reasons or resigned. Look at the entire applicant pool and measure the number of people coming in. So Dr. Bardwell didn't study that. It was not helpful because he didn't correlate anything to age. That's my point.
I'm not sure we're saying something different. I'm not sure why you're unwilling to say that the district court disregarded some of the experts, some plaintiffs' experts. I think what you're saying is, yeah, they performed an analysis, but it was irrelevant to the issue.
Yeah, that's what I'm saying, Your Honor. Thank you. I appreciate the time here.
Thank you.
Technically out of time, and I'm wondering if I could have a minute or two.
A minute.
1 minute.
You have plenty of time, but give you a minute.
Thank you. I want to point out that under 216B, there's an initial certification, which under the Thiessen case requires the same policy, decision, or plan. That's the initial certification standard under 216B. The final certification requires a higher level, a stricter analysis and a determination by the district court of whether we're talking about one trial or 271 trials. If the individual managers were making this decision, then the case gets decertified. The district court said this, that the assertions by Spirit that these were individual manager decisions without influence by upper management or anyone like David Walker, they said the case should be decertified. The court said this, those assertions, and that's at page 11 of the 2023 order, are outweighed by evidence that the plaintiffs were subjected to common policies. So the court said this was, and then in the same order.
You're taking your minute.
All right,
You can finish
my
your
point
sentence.
is this, Your Honor. The court found that there was a common policy. That was necessary and essential to a determination of final certification. And that undermines the notion that individual decision makers, individual managers made these decisions. Thank you.
Case is submitted. Counsel excused. We're going to take a short recess now.
Court is in recess until the judge returns. The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Please be seated. Feels lonely in here now. We'll start this afternoon with 23-3130, Allied World Specialty versus Blue Cross and Blue Shield.
Good morning, may it please the court. My name is Kevin Tessier, and I represent Blue Cross Blue Shield of Kansas, the appellant in this case. I would like to reserve 3 minutes of my time for rebuttal.
Can I hate to destroy your rhythm, but I have been dying to ask somebody in this case something. Since there's recognized coverage for defense costs under the E&O policy, why does this must matter whether the availability to recoup defense costs under the D&O policy is going to be significant at Blue Cross, but why?
Why what?
Well, because Allied World is already paying defense costs under the E&O policy.
Because the defense costs far exceed even the limits of the E&O policy.
Thank you.
Yes, okay. Happy to answer that question. So in this particular case, we do have an insurance policy, the D&O policy, that has an express grant of coverage for claims for antitrust activities. And that express grant of coverage includes everything from violations of the Sherman Act, violations of the Clayton Act, claims for price fixing, claims for monopolization, claims for restraint of trade. And Judge Bachrach, as you noted, Blue Cross was sued in what ultimately turned out to be multi-district litigation alleging all of those claims against Blue Cross. And in this particular case, Allied World denied coverage for those lawsuits. Now, the district court held that Allied World correctly denied coverage on 2 grounds: a managed care activities exclusion, which we'll talk about first, and then 2 different relatedness provisions in the policy, a related claims provision and then a prior pending litigation exclusion. So let's start with managed care activities exclusion. The court's analysis has to start with that express grant of coverage. So here we have an entirely separate, standalone insuring agreement in the D&O policy that says Allied World will cover claims for antitrust activities. And it's comprehensive coverage. It's all of those things I listed: violations of the Sherman Act, Clayton Act, price fixing, monopolization, restraint of trade. And here, the managed care activities exclusion that Allied World relied on does not reference that coverage for antitrust activities at all. Instead, the language in that exclusion precludes coverage for claims for alleged acts, errors, or omissions in performance of or failure to perform managed care activities. Now, if that language sounds familiar, actual or alleged, actual or error or omissions, it's because that language tracks exactly the definition of wrongful acts. And wrongful acts has its own separate insuring agreement and coverage in the D&O policy. So that's already one clue what this exclusion applies to. But as interpreted by the district court, the managed care activities exclusion would preclude coverage for any claims concerning products or services that Blue Cross buys or sells. And that creates an irreconcilable conflict between the express grant of coverage for antitrust activities claims in the policy. So an antitrust claim, by its very nature, addresses the market in which the business...
So you're suggesting it's illusory?
No.
No.
It's not. Our position is, at a minimum, that conflict creates an ambiguity. You're not sure how those 2 things interact because it does seem to eliminate, like, how could you have a price-fixing claim that doesn't involve what Blue Cross buys or sells? You can't. Applying the exclusion to that express grant of coverage to that one particular insuring agreement would nullify that term. So
Your argument really on ambiguity really isn't ambiguity because it covers antitrust activity. It's really the subsidiary elements like price fixing, monopolization, that are expressly incorporated into the antitrust activities insuring agreement.
Yes,
Got it.
absolutely, yes. So there is a well-established body of case law, which, according to those cases themselves, overwhelmingly supports the position that an insurer cannot grant coverage with one hand, and a very specific grant of coverage here for antitrust activities, and then rely on an exclusion to take that coverage away, especially an exclusion that doesn't even, reference the antitrust activities coverage in the policy. So the district court said, well, there is no irreconcilable conflict between the antitrust activities coverage and this particular exclusion because 3 claims would still be covered. So the court said first that claims against directors and officers for stealing money from the company would still be covered under the policy. But that doesn't really work for antitrust coverage, does it? Because Allied World doesn't even try to defend that example of what would be a covered claim on appeal. It's not an antitrust claim. 2 executives stealing money from the company is not an antitrust claim. And it's also not a claim against Blue Cross Blue Shield of Kansas. And the particular, even though it's in a directors and officers policy, this particular kind of policy provides coverage to the corporate entity too. So Blue Cross as a company has coverage for claims alleging antitrust activities. So that example doesn't work at all, and it's not one that Allied World defends on appeal. The second example of what would be a covered claim according to the district court is a claim involving the offering of debt or equity. And if all of these examples seem off the wall, like where is the court getting these examples? They come from a case called Benecard that that involved an insurance policy that didn't have express antitrust activities coverage. It was a wrongful acts coverage insurance policy at issue, and it didn't involve an underlying antitrust claim. So that's already clue 1 for the court that we're talking about examples that don't really apply here. And once again, that example, the offering of equity or debt, that is another example from the district court opinion that Allied World does not defend on appeal. That isn't an antitrust claim either. At a minimum, it's certainly not one that would be made against Blue Cross Blue Shield of Kansas. It's a managed care company. It's not in the business of offering debt or equity. And so it's axiomatic. You can't be sued for an antitrust violation in a market that you don't compete in or participate in. So this example really is something that would never be brought against Blue Cross in the first place. So the third example, mergers and acquisitions. So Allied World and the district court never explain why that claim, a claim for mergers and acquisitions, somehow would be outside the scope of the managed care activities exclusion. But the principal antitrust concern with mergers and acquisitions, of course, is market power. Market power. So an antitrust claim based on a merger or acquisition necessarily implicates the products and services that Blue Cross buys and sells. And here's the critical point. So if antitrust claims are in fact covered, as Allied World concedes, then there is coverage for the underlying lawsuits in our case, because those lawsuits alleged, among other things, that the rules that the Blue plans set up, the defendant set up, restricted the ability of non-Blue plans to come into the state and to buy that company and compete in the market for health insurance. So the alleged violation of antitrust law was a restriction on mergers and acquisitions. Allied World's only response to that argument, one response, is that, no, that doesn't apply here because not only does it have to be a merger and acquisition, it has to be an actual merger or acquisition. It can't be a restriction on a merger or acquisition. But Allied World is just making this up. There's no language in the policy that says that's the requirement. So you have a situation, if in fact that example is accurate, and that's the one example that Allied World said would be covered, The policyholder wins in this case. So the bottom line, by Allied World's own admission, there is only one claim, mergers and acquisitions, that would be covered by an insuring agreement that says Sherman Act violations covered, Clayton Act violations covered, monopolies covered, price fixing covered, restraints of trade covered. It doesn't add up. There's an inherent tension between those two things. And at a minimum, there's an ambiguity in the policy about how those two things interact. That express grant of coverage compared to that exclusion, which doesn't expressly talk about the antitrust coverage. And so you have a couple of key principles, I think, operating in the background here. The first is you have to give meaning to each of the terms in the policy. And Judge Bacharach, you were pointing out that the specific items appear in the definition of antitrust activities, but one of those is price fixing. And what you won't hear Allied World say to you today, and they certainly haven't said it in their briefs, and what the district court didn't say either, what kind of a price fixing case would still be covered under Allied World's interpretation of the policy? There can't be one, because they're interpreting that exclusion to say anything that relates to products or services that Blue Cross buys or sells are excluded. You can't fix prices otherwise. So what this court should hold is that there is an express and irreconcilable conflict between the grant of coverage for antitrust activities and the managed care activities exclusion, and that ambiguity alone should be resolved in favor of coverage in the policyholder, as Kansas law clearly dictates. I would like to switch gears a little bit and talk about the relatedness provisions. So the first part of the policy that the district court relied on to support that grounds for the denial of coverage says if you have a claim in the policy period, it can be related to another claim. But there isn't any language in that provision that says you can take a claim in the policy period and relate back. I know I reserve time, but I'll keep going. But that related claims provision doesn't say you can take a lawsuit filed during the policy period and relate it back to something like the Love lawsuit 10 years earlier in a prior policy period. And we cited cases that say if an insurance policy does that, there's express language that allows it to do that.
Why isn't it implicit when the relatedness provision says it shall be considered a single claim made when the first claim had been made, i.e. in this case, when the Dr. Love claim had been filed in 2000?
Well, I think that's a good question. You have to keep reading, because what it says, when those two claims are considered a related claim and it's at the earlier claim, it goes on to say, and for purposes of that related claim, there's a single retention and a single set of limits under this policy. So right there is your clue that you can't go back.
Yeah, but in deciphering the clue, does that mean that there's two separate points in the relatedness provision, or are you assuming that they're all integrated? In other words, it's a retention. It's a limit on the policy under the sentence 2, but isn't it also a reasonable reading that also it means that it's a single claim that is deemed made when the Dr. Love claim had been
within the policy period, because it's telling you have to have a single set of limits and a single retention for that claim. It doesn't have the language in the other policies that we cite in the cases that say it doesn't matter if it goes back to a prior policy, that's okay.
Okay.
Our policy at issue in this case doesn't have that. On the prior pending litigation exclusion, again, the district court made a similar error. It relied on the language in the exclusion that applies to claims for wrongful acts. But the key language that would apply to claims under the antitrust activities insuring agreement is alleging or derived from the same or essentially the same facts. And here, it's not even close. The antitrust litigation has fundamentally different conduct alleged. It's dividing the country into exclusive service areas, fixing prices through the Blue Card program, implementing the rules that I talked about that restrict acquisitions and non-blue business, where Love, the lawsuit 10 years before the policy period, related to a conspiracy to manipulate claims handling systems, to downcode, to bundle claims. And in that RICO case, it was the predicate acts were mail and wire fraud. So you have something that's not even close to be considered related under the PPL exclusion. Thank you.
I need to ask a question. I might have misunderstood you earlier, but I thought you said that the language in the exclusion for managed care activities, that language tracks some coverage language in the policy, is that right?
That's right.
And what language in the coverage provisions is that?
The definition of wrongful acts. So in the managed care activities exclusion precludes coverage for any claim alleging, arising out of, based upon, or attributable to.
It's GG3 that it tracks in the definition of wrongful act. Is that what you're saying?
Let me see, I will tell you what the. Yeah, GG1.
GG1.
Yeah, that whole section there, yes.
Okay, thank you.
Thank you.
Hi, may it please the court. I'm Joseph Lang from Carlton Fields in Tampa for Allied World Specialty Insurance Company. At council table with me is Heidi Rasky, who is also on the brief with me. I hear a lot about what we have admitted or conceded or waived or acquiesced to is to the breadth of this managed care activities exclusion. So I think right out of the box, I want to talk about some things that, depending on the allegations in a given complaint, would be not covered by the MCA exclusion, and therefore it doesn't do, as is being speculated, take away everything that was given with the left hand, take it away with the right hand. We can talk about agreements. First, as an overview as to all of this, there's a difference between running your managed care organization and running the business as a whole vis-a-vis other competitors. And so I think that's a very important distinction that goes into many of these examples I'm about to give. But agreements with competitors not to poach each other's employees, agreements with competitors to fix salaries of the executive employees within the various competitors, or to fix salaries. Those are things that would fall, depending on the allegations in a given complaint, fall outside of the managed care.
So you're saying fixing salaries horizontally with other managed care activity organizations?
With other competitors that may not even be managed care, other competitors in the broader insurance market, that there's a difference between running your own managed care organization, which is what these allegations in this lawsuit, the MDL lawsuit, are about, and the business's outside world.
Okay, so as I understand it, because your adversary is arguing, well, the price fixing is one of the components in the insuring agreement for antitrust activities.
Right.
And what he's saying is, well, this entity, Blue Cross Blue Shield of Kansas, they sell managed care activities. And so for price fixing, he says that you can't price fix your sale of managed care activities and be covered if the exclusion covers all managed care activities.
That's all we do.
Like if I sell widgets
Right.
and and I get a liability insurance policy that says you are protected for the sale of widgets, and then there's an exclusion that says, well, there's an exclusion for the sale of widgets, or let's say I'm protected for price fixing, and there's an exclusion for, well, there's an exclusion for anything involving the sale of widgets. Well, I can't, if you're talking about the sale of the ultimate consumer, there's no scenario, I assume, that I can actually invoke my insurance agreement for for price fixing. But what you're saying is, well, it also covers not only the sale of the ultimate consumer, but price fixing can be horizontal with salaries.
Yes, Your Honor.
Did you ever argue that in your, I didn't notice that in your briefing on appeal. Did you argue that?
That particular example is not in our brief. We do embrace the statement by the district court and also by the Benecard court, you know, quote, myriad other claims against directors, officers arising from commercial transactions. So anticipating the way this argument might go today, I tried to come up with some more concrete examples.
Well, there's, you know, yeah, and the judge says, like, Benecard, well, if you ignore the subsidiary elements like price fixing, monopolization that go in, that are specifically incorporated into the insuring agreement for antitrust activity, if you put those aside, yeah, there are certain, hypothetically, you argue, antitrust claims like mergers and acquisitions, et cetera, or stealing from employees, they say. But there's nothing that the judge or you in your briefing actually addressed how you can take advantage of this insuring agreement for price fixing or monopolization if you're going to exclude anything involving the only product that Blue Cross Blue Shield of Kansas sells, that is managed care activities.
Well, I think I just gave an example of the poaching of employees, the fixing of salaries. This is at the corporate level, dealing with other competitors. Also,
The problem is you're raising this for the first time, you know, in oral argument on appeal. The district judge didn't have the benefit of that, and frankly, we didn't have the benefit of that until you just said it.
okay, but defending the district court's order, the district court points out that this is not illusory. I mean, we don't even hear an allegation today. I think he acknowledged it's not illusory coverage. The coverage at issue covers many, many things, and there's no ambiguity in the managed care activities exclusion as to how to read it. This ambiguity argument as between the two, I don't know of any Kansas law that has adopted that. We do say that in our brief. There's no Kansas law that we're aware of that has adopted that ambiguity argument. There's plenty of things that would be covered by this insuring agreement, and the managed care activities exclusion is very clear. So we don't see where the ambiguity is.
Well, I do.
Okay.
The exclusion for managed care activities looks awfully broad to me. Alleging arising, any claim alleging arising out of, based upon or attributable to any actual or alleged act, error, or omission in the performance of or failure to perform managed care activities. So it's, if it's price fixing, that would seem to be something that arises out of your managed care activities, because that's when you're setting prices. On the other hand, and this is something else that just occurred to me, it looks like the managed care activity exclusion negates the whole policy. You can't do anything that isn't within that definition of managed care activities.
But that's what I'm trying to explain, is this is a D&O policy, unlike the E&O policy, where this exclusion was not included and coverage was provided under a reservation of rights by Allied World. In this policy, this exclusion was included, obviously negotiated. This,
What would you mean by obviously negotiated? This exclusion was negotiated?
well, no, I mean, these were both policies were purchased at the same time for the same policy period. So there was an awareness, of course, that there's a difference between the two. I don't think there's even been a denial of that. But this D&O policy covers a whole host of activities that are outside the managed care, the operation of the actual managed care operation, all types of activities that would be at the corporate level of Blue Cross Blue Shield. Antitrust conspiracy allegations, for instance, to steal proprietary information. We did not acquiesce that a director stealing information would not qualify. That was an example that was given in the cases. And a conspiracy
So you're
would,
saying that would be covered against Blue Cross?
I think what my colleague was indicating was a single isolated theft by a director where the company wasn't involved at all. But what I'm saying is a conspiracy where a director or numerous directors conspired with a competitor to steal information from one side or the other, I think Blue Cross could be sued.
And that would, under an antitrust theory?
Yes.
Okay.
And that's my point, is that these general corporate activities are outside of the actual operation of the managed care activities, and that's where the D&O policy really focuses, and that's what sets it apart from the E&O policy. And so I would urge you to affirm on this basis, and of course, affirming on this basis pretty much is determinative of the case, so you wouldn't need to reach the other two, but we do have two other bases, alternative bases by the district court for this ruling, each of which are independent and sufficient. I want to talk about this related claims provision. First is to how it applies, because Your Honor was asking about my colleague's position as to how it applies. Related claims provisions apply both ways, forward-looking and backward-looking. And my colleague would have it apply just one way. One way that a related claims provision applies is to capture all claims that might arise after the policy period that are related to a claim first made in the policy period, and pull those claims back into this policy period if the claim was first made in this policy period. And that is what the sentence at the end that he is referencing would apply to, is that pulling back of future claims under future policy periods.
You're talking about the notice provision, the last sentence of the notice provision?
Right, I'm talking about the limit
It
of
says in
liability.
such event, only one limit of liability? That's what you're talking about?
Yes, Your Honor,
Okay,
and that's if you're.
That's part of the notice of claim provision.
Right, and that's if you have a claim that's first made in this policy period, and then later down the road, there are other claims, it would pull them back into this. But the other way related claims provisions work, and there's an abundant case law that we cite on this, is backward-looking, which is if a related claim has already been made earlier in a different policy period, all claims get pushed back to those prior to the first claim made. And that's what the district court judge decided here.
That first claim, is that under the policy, or is that 15 years ago, somebody did something, and now there's the same thing comes up later on with the policy? That's gone because of
Correct.
the related claims.
If it truly is related. But yes.
Well, how is it, how do you determine if it's related? In other words, I got the impression if it was the same title, that made it related if it was now 10 years later.
The same title, like?
In other words, let's say the individual was charged with X 10 years ago, and now 10 years later, the policy's in force, and he's charged with a different count of X.
No, Your Honor, it doesn't have to be the exact same claim. It has to be substantially similar factual circumstances. And if the district court judge did, I think, a remarkable job of laying out those similar circumstances with the Love litigation, because both the Love litigation, which is what is the related claim, and the current litigation all arise out of the same operations of the managed care
Not the same conduct, but the same instrumentalities, like the blue
Well,
card?
much of it is the same conduct, too. The way that they are arranged, the way that,
So you're saying in the Dr. Jones litigation that there was a theory of liability that Blue Cross Blue Shield was committing price fixing through these ESAs?
right, well, through the same mechanism because of the way they have set up the geographic, the blue card.
And that there were these horizontal limitations in the Dr. Jones litigation saying that one blue can't compete against another blue, and that was going to
Correct.
result in underpaying.
And pages
providers.
42 to 44 of the district court's order goes through those comparisons in detail.
It's not that they're the same cause of action. They're based on at least some common facts.
Right, the same predicate, the same mechanism by way it, but it doesn't have to be the exact same cause of action, it doesn't have to be the same parties.
But it does have to be the same conduct, doesn't it?
It does have to be, at some level, the same conduct. Not every piece of the conduct has to be identical.
Yeah, but if you had, let's say they bill through the blue card system. Well, yeah, so 40 years from now, there is a completely different theory that Blue Cross Blue Shield of Kansas committed this illegality through the blue card system. You're going to say that had to have been made in 2003 because in 2003, there was a claim in the Dr. Love litigation that they used the blue card system. Or that let's say 100 years, they were underpaying pharmacists through their manipulation of the blue card system. Different than the Love litigation, different than the MDL, but all of that had to have been made under this notice of claim provision in 2003 because it used the same instrumentalities.
If it's the same mechanical predicate that allows this to happen,
Yeah.
then I don't think the passage, I mean, that's an extreme hypothetical, that many years on.
We're talking about 21, right? Or 16, yeah.
But the passage of time is not the key element. It arises from the same substantially similar factual circumstances, and the judge identified what those are and on pages 42 to 44, and I would urge, it's much more than the reply brief would indicate those are. Oh, I'm sorry, I'm happy to answer any other questions.
Let me ask you on that notice provision we talked about a little while ago. The initial litigation here was the Love litigation, is that what's?
Yes, Your Honor.
So under that notice provision, as you understand it, if Blue Cross had been covered by an allied policy at that time, by policy with same provisions, then the present case would be a related case. And if there's any money left over after paying the attorney fees in the Love litigation, you could use, that could be used for the MDL case, is that right?
In your hypothetical, I think that is how a related claim clause works in the forward-looking way, so yes.
But now we're using it backwards. We're saying it's related to the Love, and
Right,
therefore.
but I'm saying from the Love policy's point of view.
Yeah,
From the Love
okay.
I'm sorry, that's where from the Love policy's point of view, if it had had that same provision, it would pull related claims back into
But in
that.
this case, there was no allied policy at the Love time, or do we know whether there was an allied policy?
I hesitate to answer that question, I'm not sure exactly.
Okay.
I would like to end, though, because the reply brief says numerous times that we waived arguments and cites the Donahue case from this court. And obviously, as the appellee, this court is welcome to affirm on any basis, but we don't waive an argument by not having made it below in defensive.
Well, we do consider it under Elkins versus Comfort, don't we?
What's that?
In other words, if you didn't brief something in district court and you brief it now, that's at least one of the factors that we take into account in whether to affirm on alternative grounds.
Oh, there's complete
we
discretion in the court whether to affirm on alternative grounds.
Yeah.
You have all kinds of, and that very well may be a factor, but it is not an absolute waiver barring plain error for an appellee
Yeah.
to give an argument, not raise a new issue, but to give an argument in support of an issue that was well preserved. And so I take issue with the citation of the Donahue case, which was focused on an appellant seeking reversal. We would urge the court to affirm primarily on the managed care activities, but in the alternative on any of the three grounds that are independent and sufficient to support this judgment. Thank you.
I'm happy to answer any questions that the panel may have.
Questions?
I've questioned it out.
I don't understand it well enough to ask a question.
Join the crowd. Thank you, counsel. Case is submitted, counsel are excused. Let's get ready for the next case. 23-3225 International Brotherhood of Boilermakers versus Jones.
Does he look like a Boilermaker to you?
Pardon?
This guy look like a Boilermaker?
Good morning.
Leaving the doors closed, so, just so we don't get interrupted. I'll let you know.
Good morning. Matt Vianello on behalf of the appellant Newt Jones, and I'm going to reserve 3 minutes for rebuttal. This case, the defendants in this case have done everything they can to disregard the rules of procedure to get the result that they wanted, which is to remove the international president from his role. And it's a fundamental issue of due process throughout this, and it reminds me of something that I read, Judge Hart's, that you wrote, which is, what justice would there be in a society whose members could not resort to the resolution of disputes by a tribunal that must apply neutral principles in a consistent manner? And
Wonder who I quoted for that.
I think it was yours. It was a Denver Law Review article.
Oh, okay. Not precedential.
No.
Nobody joined that.
No, not precedential.
Surprise.
So the issues that we have here along the way are numerous. Basically, the defendants in the case have taken the position that they are supreme in every respect and by and large pick and choose parts of provisions of the International Union Constitution that support them and to the disregard of basically anything that is contrary. So starting with filing charges. They are, at the outset, the charges that were alleged were not specific at all. There are a number of cases that address this, that you need time, place, date, and that failure to do that is inherently prejudicial. Now that gets into the LMRDA issues, but from a constitutional interpretation standpoint, at the outset, the defendants declared that an office of the president was partially kind of vacant for a limited period of time and appointed somebody to do certain roles of the international president. There's no authority in the Constitution that says that you can do that.
Doesn't Article 17 give the IEC exclusive jurisdiction over charges against IBB officers?
Yes, Judge. So
It seems sort of strange that you'd argue that, well, Mr. Jones is the one that was stealing all the money, theoretically, but he's the only one that can do anything, and nobody else can do anything because he's the president.
Well, so I think that that is, to some extent, a narrow view. That exact same section that you're referring to, 17.3.2.
Can you pull the mic over a little bit?
Sure. So that same provision that you are referring to, 17.3.2 says the Executive Council has exclusive jurisdiction. It also says any member of, it says the executive, where's this? Executive Council shall have exclusive jurisdiction to hear charges against a subordinate body and against an international president. And then it says any member of the Executive Council who is directly involved in the proceedings so that the council member cannot function in an impartial manner shall not participate or be subject to a challenge. Now, that provision cannot be read in isolation because there are other sections, conduct of the hearing, that says that the required, it actually gives the international president authority to
But the
appoint.
international president is the defendant.
Yes,
And it seems really strange to say the defendant's going to tell us how everything's going to be done here.
and there is
I'm innocent.
and there is a number of safeguards. So one thing that happened here, so let me go back a second and say there has to be a constitutional provision that says it. There's nothing that says that you can appoint somebody in the manner that this was done here. Now, I understand that there's a conflict, potential conflict of interest, so it's important to look at what actually happened. Newton-Jones did not schedule a hearing. He did not dismiss the charges. He did not take any action except for to appoint other people to fill his role, which is his exclusive authority. Now, Judge Kelly, to your point, there are a number of safeguards within the Constitution that allow for an orderly processing of this matter. So, for example, in Article 5.8, I believe, or 5.2, it says that any decision or action by the international president can be appealed, proper appeal that is, to the International Executive Council. So if there's no decision that's made, if there's some decision that's made, if there's something that's done that they don't like, there is an orderly process that you can follow.
To appeal a determination of interpreting the Union Constitution, right?
It's actually, so that is Article 7.2 that says all decisions shall be binding unless reversed by the Executive Council or appeal to the Executive Council, but it's actually broader than that. So if in Article 5.2, which outlines the powers and authorities of the IEC, it says, it shall have the power to pass on any subject, proposition, or grievance, and hear and determine all cases of appeal from the decisions and rulings of the international president which are filed by registered or certified mail. That's not limited to interpretation.
Okay, but doesn't Article 1.5 say when the IBB is not in convention session, the executive, i.e. appointing an investigator, like Creedon and McManaman, and judicial powers are vested in the Executive Council, not in the international president?
But you can't read all those provisions in isolation, so you have to look at the entire Constitution. And so, first off, Article 1.5.
I have a fundamental question here. that
Yes,
I'd
Judge.
like you to address before we start interpreting the Constitution. Because in this case, I'm looking at the various provisions of the Constitution, trying to figure out, for the reason, in the manner you're talking about, how to interpret it. But that's not our job. We defer to the Union on interpreting the Constitution, and as long as it's not unreasonable, it may even be a more lenient review than that, we adopt the Union's interpretation. The question here is, who's the Union? And what occurs to me is the only reason the only purpose for our interpreting the Constitution is to find out, in this circumstance, who is the Union? Is it President Jones or is it the IEC? Do you agree that that's what we're supposed to do?
I think that is, so yes, I think there is a little more than that when it comes to LMRDA impartiality, but as far as...
If you're relying on the NLRA, then yes.
Yes. So to your point, and yes, you can disagree with an interpretation. The case law is pretty clear. The courts don't have to agree with it. They can only reject it if it's patently unreasonable.
Patently unreasonable is what you think is the test?
I think there's two tests, I believe, but let's just go with unreasonable.
Okay.
Okay? And so the starting place is, there is an element of looking at the Union Constitution that the court has to do. So the first question is, who has the power to interpret? And that provision is clear, which is that the Union president is the one who interprets it. Now, Judge Hartz, to your question, or I think Judge Bachrach, you brought it up, there is some general provisions in Article 1, and then there are very specific provisions about what the IEC does, what the international president does. And that's in Article 7, and it delineates what their power and authority is. But one of them that is express is that the president gets to interpret the Constitution. Now, the safeguard here, to your point, Judge Kelly, or to what you were asking, if there's an interpretation that somebody doesn't like, and this isn't even before it gets to the court, but if somebody doesn't like that interpretation, action of the international president, it can be appealed. But there has to be a proper appeal, and what's happened in this case is the certain members of the IEC have said, our interpretation controls. The international president doesn't get to interpret. And the question that I have there is, where in there, in the Union Constitution, does it say expressly that the IEC gets to interpret? And there is one,
Go ahead.
there's one place, which is on a proper appeal.
No, well, I think I wish I thought I'd written down the provision. But very early in the Constitution says I think the legislative and executive authority of the Union is vested in the IEC. Do I have, maybe you obviously
I
have the
do.
language
So
right there.
it's, and this is actually a limiting provision. Okay, so it says powers of the International Brotherhood. This is 1.4, and I referenced this in my reply brief. 1.4, powers of the International Brotherhood while in convention shall be legislative, executive, and judicial. Then it has vesting of powers 1.5. When the International Brotherhood is not in convention, its executive and judicial powers only shall be invested in an international executive council. Now that's a limitation because it takes out this judicial aspect, but
Takes out the legislative.
legislative aspect.
I'm sorry.
Now, the point here, though, is if that is carte blanche authority, then why even have an Article 7? Why even say that the international president is authorized to interpret, and then say that interpretation can be overturned on proper appeal to the Executive Council? Why have that at all if just stop at 1.5? Why have it?
Okay, let's just say everything, we're with you, everything you just said. Where in the record did President Jones hear and determine any constitutional provision?
So,
Now, you refer to his actions, he certainly acted in appointing Mr. McManaman and Mr. Creedon, but where did he hear arguments? So I don't know if there was, if you'd appeal, there was no hearing and determination of any interpretation of a constitutional provision to appeal under 7.2.
There are certainly interpretations that had been made, and those are outlined.
Where? That's what I'm asking. Where in the record?
So in the record, there's not a specific instance of, at the international union level, before the, where there was an argument about what is the interpretation of this, okay? But you also have to look at Article 7.1, which talks about that the international president is the chief executive. His decisions, basically, in all of these provisions throughout the Constitution, there's a subordinate aspect with the IEC. And so, but let's take your point, Judge Bachrach. So if we say that there has to be this specific instance where there has to be an interpretation, where there has to be some event that occurs where a question of an interpretation comes up, okay, fine. If that's the case, then how is it that the IEC can just interpret on its own without having to do anything? And so,
Well, because the point is that that Article 1.5 doesn't say doesn't have that here language. What it does say is that whether it's limiting or affirmative vesting of power, that the executive and judicial powers are vested in the IEC, and in the actual decision on June 2nd, the decision itself is replete with actual interpretations of specific constitutional provisions. They did exactly what President Jones failed to do.
Well, I disagree with you there because there are a number of letters that are cited throughout the brief where he starts off specifically and says Newton-Jones, President Jones.
Well, except section 17.3.2 restricts Jones' ability to participate in the proceedings.
It also...
He's either in or he's out, and he's out based on that.
What is the proceeding? So that's the hearing. So how is it that anything he's done before that is the...
You don't think the appointment of who's going to conduct the proceeding is part of the proceeding?
If that's part of the proceeding, then so is one of the members showing up there to form part of the quorum. If that's participating, then so is Foltz showing up and serving as part of the quorum. You can't have it where his participation stops at one point and he can't do anything, but then another person can show up and be part of a quorum, make up a quorum, and say, "Well, we get to proceed."
So what was good for the goose is good for the gander. They both really violated the provision. Because I understand your argument. That's exactly what you said in your brief, but I really didn't hear an answer to my colleague's question. I mean, what I heard you say is, well, if they did it, then they did it. I mean, that's what my kid says.
Okay, well, and I'm over my time here, but if I can address this.
Let's get this straightened out.
Sure. So the proceeding itself, where does it start? Does it start with the filing of the charges? How far does that go? And so you're asking about the proceeding. There's nothing that says that there's an automatic exclusion, and I addressed this in the brief. The reason why there's an impartiality provision, this goes to the LMRDA, is to protect due process rights. So I don't agree that anything that happened before the actual hearing is the proceeding. Now, and I also don't agree that there's an automatic exclusion. And so it says to Judge Kelly, it says in there that you shall not participate or be subject to challenge, which means that there is no automatic exclusion.
17.3.2 says the executive council shall have exclusive jurisdiction to hear charges against subordinate bodies and international officers. And any member who's directly involved cannot function in an impartial manner, shall not participate or be subject to a challenge for cause.
And it's that second part, or be subject to a
challenge. Going around a circle, I mean.
I disagree. The part where it says, or be subject to a challenge for cause is a limitation. It means that it does not happen automatically. If it happened automatically, saying anybody who's involved is out, you wouldn't have the language that follows, or be subject to a challenge for cause. And again, that provision cannot be read in isolation because you have everything else that says the international president does this, international president does this. And I understand it's against...
The international president can't take money that he shouldn't take.
Sure, I understand that. And there's still due process rights of an accused to be...
Speaking of due process rights, he never showed up to any of the hearings. He sort of waived all those due process issues.
Well, unless that hearing wasn't a legitimate hearing.
Why wasn't it a legitimate hearing?
Well, it wasn't a legitimate hearing because they didn't have a quorum.
Okay.
So that's one issue. It wasn't a legitimate hearing because there were representatives who showed up who weren't allowed to review evidence.
Well, they denied they were representatives, specifically said, we're not representing Mr. Jones.
But then the IEC said they were representatives.
No, they didn't. They let them watch. They were members. They can come in and watch.
They were not allowed to participate.
Well, I think what they said was, what I had maybe it was just my interpretation, was Jones, they were there because as representatives of Mr. Jones, maybe I've got my kid in the section. You know, my kid is there as a spectator, as my representative, but it doesn't mean that my kid is authorized to get up and participate and say, you know, I'd like to see all of the evidence that was presented in this case.
Sure.
You know,
But
so I think they were just trying to say Jones obviously knew about this hearing.
well, so to answer your question though more fully about
Yeah.
this, why it was an illegitimate hearing, you had issues of being able to call a meeting.
Do we really?
It's addressed in the
understand
brief.
Your points.
Yeah.
I don't think you need to go into that.
Okay, thank you.
Thank you. Mr. Rosenfeld?
Good morning. I think it is still morning. It's David Rosenfeld on behalf of the
Is it?
Appellees, the 4 IVPs. I've argued many circuit courts.
Pull the
I've argu-
microphone down a little bit over your, there you go.
Thank you. I've argued many cases, and I've never heard an opposing colleague dig such a deep hole for himself. Judge Kelly, you're right. The Constitution is extremely clear that the IEC has exclusive jurisdiction over charges against subordinate entities, which wasn't involved, or a member of the IEC, of which there's 6. And that's from the get-go. And in this case, Mr. Jones tried to avoid that command by appointing his own dubbed Article 17 committee and appointing his friends to that committee, when automatically the IEC had control. Now, counsel made an argument that dug even a deeper hole for himself by saying it says, or subject to challenge. And what that really means is if that international officer insists on participating, even though they are automatically disqualified, they can be challenged. So that reaffirms the proposition that if the charge is against you, you're automatically disqualified, you can't take action, the IEC then controls the process. And I think that ends the case, and Judge Melgren began his analysis when he issued the declaratory relief from exactly the question, Judge Kelly, you asked, which was, does the IEC have control of this? Which it has to.
But what if it makes the decision at a meeting or hearing where there's no quorum?
Well, Judge Melgren addressed that question. And he said,
Like you two also.
okay. And what he said was that the way he read the Constitution, the word quorum, was that there were 4 members of the IEC present, which is a quorum of 6. He didn't dispute that. One of the 4 was John Foltz, the International Vice President, who was there to participate as the charging party, but not to vote. And Judge Melgren properly held that 4 is a quorum, and that met the standard. I just want to...
What if we disagree and think that there were only 3 there because someone who's disqualified because he's participating doesn't count toward the forum? What do we do then?
We have 2 answers to that. One is that's all waived because Jones never showed up, didn't protest, didn't raise the question, and so he's waived or abandoned
You
that.
actually have to show up at a hearing, and then you're going to, but he is damned if he does, damned if he doesn't, because he's a member of the IEC. So if he shows up, then he is the 4th member. He has now satisfied the quorum requirement.
Well, I can avoid his damned if he does, if he damned if he doesn't, because he was well aware of these proceedings, but he took the tactical position that his own self-appointed Article 17 committee would proceed. So all he had to do, Your Honor, was simply write a letter, which he was fully capable of doing, saying that that there would be no quorum if Larry McMahon doesn't show and John Foltz can't participate. Or the day after the hearing, or 2 days later, when he got the decision saying this is invalid because there was no quorum. And because of his tactical decision not to comment, not to get involved, but to rely upon his self-appointed committee, he never raised those questions. And
What's your other basis besides waiver?
Well, the fact that the IEC held in its decision that it was, that it was properly constituted, and it also held that he waived any procedural rulings, and the IEC was fully authorized to do that.
I'm sorry, did it specifically say that there was a quorum?
No. It just addressed, it said broadly that any procedural issue has been waived. And I think there's something else that counsel sort of dug himself a deeper hole in with respect to the power of the IEC, and that's in Article 5, in Article 5.2, which defines the powers of the Executive Council, the IEC. If I can just read the sentence here, it says, it shall have the power to pass on any subject, proposition, or grievance. Pretty broad. And then it goes on to say, and hear and determine all cases of appeal from decisions. So it has two powers. One is to pass on any subject, proposition, or grievance, or secondly, to hear an appeal. So when it acted to issue its decision in early June, it was authorized to do so by the language of 5.2. And I think there's a point that I can make, kind of having represented unions for a long time, that I think is evident in this Constitution. That some constitutions give a lot more power to the executive. Maybe this reflects on national politics too. Others give more power to the executive board or executive committee, and others split it. And I think, Judge Kelly, when you pointed out that Article 1.5 says, when the International Brotherhood is not in convention, because ultimately the convention is the union and controls what goes on, its executive and judicial powers are vested in the International Executive Council, not in the president. And the words not in the president aren't there. But this union says, we're going to give to the 6 members of the IEC. And keep in mind, structurally, the IEC has 5 vice presidents who are elected and the international president. So the international president has some power as part of the IEC, but ultimately, this union is controlled during the 5 years between conventions, because international unions only usually hold conventions every 5 years, by the IEC, and it has both judicial and executive power. It does not have legislative power, which means to amend or change the Constitution. And that's the way this union functions. And counsel is correct that you look at the whole Constitution, and there are many provisions in the Constitution which say things can happen subject to appeal or approval by the IEC, which reaffirms my view, the argument I'm making to your honors, that this union is based on this kind of system where the IEC, the 6 members, control the union. And in this case, 17.3 got involved because there were charges against the international president. And so he was automatically disqualified. So the rest of the process was left to the remainder of the IEC, the 5 other members, the vice presidents, because he was automatically disqualified from taking any action, including setting up this self-dubbed Article 17 committee. And I stand here before you sort of sad about this case because of what happened here, not because of the process we use, but what is reflected in what was going on in this union. And I think the Executive Council thanked John Foltz for bringing these charges. And what you saw on the record was when they started bringing these charges, Newton-Jones retaliated against them. He took away certain responsibilities that these international vice presidents had, brought his own Article 17 charges, and then when a hearing was held where he could have shown up to explain why he was traveling to the Ukraine on the union dime, or why he was having all these meals around his home, or why he gave his wife a substantial salary increase while she was living in the Ukraine, he chose not to do so. And although the record doesn't reflect the reason, I think it was quite clear why he chose not to show up, because as revealed in February, when this whole thing came to just of concern. So I'll just conclude by saying that this union acted promptly, responsibly. Judge Milgren saw that. I just want to point out that Judge Melgren handled this thing in an expedited manner. The first day we showed up, he says to the lawyers representing IBB, you can't represent the IBB. He then set another hearing date, denied our preliminary injunction request, but said, I got to get this resolved, and then granted the declaratory relief. But by that time, Newton-Jones had left the union, and so part of this is moot because he voluntarily left. It hasn't ended this dispute, but that's the status. So unless there are questions, I'll rest. Thank you.
Thank you.
I think I'm out of time unless there's...
No. Case is submitted and counsel are excused.
Thank you.
Final case for the day is Bertels versus Farm Bureau Property and Casualty Insurance, number 23-3276. It's not 12 o'clock yet?
Oh, yeah, it's 12:10.
Oh, okay. We're not just paid off as I thought we would be.
Well, good afternoon. May it please the court. I'm Randy Rhodes. I represent the appellant, Autumn Bertels. I would like to reserve 3 minutes, please. We're here asking the court.
What happens to those reservations of time?
Planning on honoring it. The last 3 times I've been here, I haven't gotten to give a rebuttal, so it's hopeful. Let's put it that way. And that's also the first time I've got to say good afternoon. So it's an interesting day, and obviously Mr. Hall and I aren't nearly as popular as the folks who argued before us, but be that as it may. We're here asking this court to reverse and remand the summary judgment entered by the district court in favor of the appellee Farm Bureau. I'm going to touch on 3 issues today that I think are relevant to the standing issue. First, I want to talk about whether the non-claim statute can be and should be tolled by 60-515A. We think it can and it should. 2, I want to talk about whether there was consideration in support of the Glenn versus Fleming agreement. 3rd, and lastly, and subject obviously to whatever questions you may have, I want to talk about the judgment rule and why I think the district court erred in not applying the judgment rule.
If I understand you correctly then, that you are not challenging the proposition that if the assignment was improper, that you lack standing and the court lacked jurisdiction?
We believe...
Okay, you're accepting that proposition?
No, we believe the assignment was proper.
No. If, given what you're challenging, I inferred from that you're accepting the basic proposition that if you don't win on those 3 issues, the court had no jurisdiction.
I would agree with that.
Okay, that's what I wanted to be sure.
I'm not in dispute with that. Okay. So with your permission, I'll turn to the non-claim statute and whether that can be tolled. And I would refer the court first to the Sutcliffe case, which we cited in our brief, that said, yes, in fact, the non-claim statute can be tolled. And I think it's interesting in that regard then to look at how Kansas courts have interpreted the non-claim statute. And a case we cited, Nelson versus Nelson. There's a handful of other cases we didn't cite, but we cited Nelson. The other cases are Union National Bank, Grinrod's Estate.
You cited these in your brief on appeal.
I'm sorry, sir.
When you say you cited these cases, that was in your appellate brief, right?
Yes, sir, it was. We raised this below.
Well, one sentence? One sentence is all that you devoted to challenging the constitutionality of the claim statute.
I'm not talking about the constitutionality right now, Your Honor.
Okay, you're just talking. But it's
These cases.
I'm sorry, I apologize.
No, well, I apologize if I was unclear, sir.
No, you weren't unclear. I goofed.
Okay. The point of these cases is, these cases looked at the non-claim statute and what the introductory phrase, all claims, whether that was inclusive of everything or whether there was an exception. And all of those cases held it is inclusive unless there's a statutory exception. And that's important because in Frost versus Hardin, in a case I argued here in front of this court, Frost versus ADT, the issue was whether there were policy concerns or there were statutory reasons why 60-515A didn't apply. And in Frost versus Hardin, the Kansas Supreme Court said we can perceive no statutory reason why 60-5.5A or 515A should ever not apply. This court, in a case I argued, Frost versus ADT, I lost it. Not unusual for me in this court. Hopefully this case is different. That case involved a statute of limitations, a one-year statute of limitation that was in a contract, the ADT security contract. I represented the minor child of a parent who died in the fire. And we argued 60-515A told that statute of limitations for at least 8 years under the terms of the statute. And this court said no, because this was a special statute of limitation that was agreed to between my client's parent and ADT, but said there's no statutory reason that we should apply 515A.
Well, what does In re Woods Estate do to this issue?
Yeah, In re Woods Estate is an interesting
Looks like it
case.
carved out the infant exception.
I would respectfully disagree, Judge Kelly. I don't think that it did carve it out because that case involved an adult. And if you look at what In re Kelly did say, they said simply that when the statute of limitations under 515A expires, the non-claim statute can extend it even further. Okay? This is a case really of first impression with respect to whether 515A can toll the non-claim statute. And I think we have to engage in some statutory analysis here.
Doesn't it matter, you just said that the non-claim statute can toll another provision. Here we have sort of the inverse, right? We have the non-claim statute that would cut it off, and you're saying that there's another statute that can enlarge the period of limitations that's prescribed under the non-claim statute. So it's really the inverse of that case that you're relying on.
Exactly. That's my point. Yes, sir. I think that...
Well, I don't understand how that helps you. That seems to...
Well, it helps me because In re Woods dealt with an adult. And in that case, they didn't say, well, the non-claim statute can't extend. In fact, this Kansas Supreme Court said it could.
Yeah.
And it didn't say that the non-claim statute didn't get affected by 515A. It just said it could extend it. Here, we are in the inverse situation, and we're saying we believe, we contend, that 515A can, in fact, extend the non-claim statute because of the language in the statute itself and the policy reasons that underlie the statute. And again, case of first impression.
Okay, let me ask about the policy reason. The reason for the non-claim statute is so you can close an estate. The money needs to be distributed to the heirs, creditors, and so on. And you're leaving that open for as much as 20 years?
No, not in Kansas.
17?
Not in Kansas.
How long does the minor have?
Well, it depends on the claim. In any claim, but a claim involving childhood sexual abuse, there is both an extended statute, but there's also a statute of repose, 8 years.
Okay. What about other cases, other claims?
The only other statute that would be applicable would be the longer statute recently amended by the legislature for childhood sexual abuse. Those would be the only two timelines.
I'm sorry, I'm totally misunderstanding something. I thought you were relying on a tolling statute that you think should apply to the non-claim statute.
Yes.
What does the non-claim statute, the tolling statute say with respect to minors?
8 years.
Okay. So Well, now I see what you're saying. It's not 20 years, it's 8 years.
Correct.
That's pretty tough when you're talking about an estate.
That would be tough unless and until you compare it to the policy reasons underlying 515A. And again, the Kansas Supreme Court has expressly addressed that and said, we find no statutory authority, and that would include the non-claim statute, that would require us not to apply 515A. And I certainly understand the commentators and the courts having an interest in the quick and expeditious resolution of the states. I agree with that. But when you're dealing with a minor, it's a whole different situation. The Kansas courts have said the interest, I'm sorry, Your Honor, I didn't mean to interrupt.
Well, I did interrupt you, but I wanted to get to something I think goes to the heart of it. We have to interpret Kansas law then. How do we go about predicting what the Kansas Supreme Court would do? Are there cases in other jurisdictions that involve a non-claim statute and a tolling for minors?
Well, you're allowed to interrupt me. I'm not allowed to interrupt you. You don't need to apologize. We have not cited any because I haven't found any. I think
No cases one way or the other?
one way or the other. This is a unique situation. I would, however, Your Honor, I would refer you to another case that this court decided that I had the privilege of working on back in the early 1990s, Gardner versus Chrysler, where in that case involved was the statute in Kansas that says if I don't wear my seatbelt in a wreck and I file a lawsuit, the defendant can't say, hey, Randy didn't wear his seatbelt. That's comparative fault. So in the Gardner case, the plaintiff, Ms. Gardner, argued, well, it can't come in for any reason. And I had the privilege of representing Chrysler in that case for a while. And we said, well, it doesn't come in for comparative fault, but it can come in under the language of the statute for other reasons, for example, for proof of defect. And that's important here because here, the Kansas statute for minors, 515A, says, except as provided in, and they list the statute for
Sexual abuse.
for the childhood sexual abuse. This applies, this tolling provision, this 8-year provision. And under Gardner versus Chrysler, this court said, hey, when the legislature says this is the reach of the statute, that's the reach and it doesn't go any further. So in applying this statute and interpreting Kansas law, they're asking you to say, well, that prefatory clause should also include the non-claim statute. And we're saying, no, it doesn't. The legislature never intended for the non-claim statute not to be told by 515A.
You've got 3 minutes if you briefly discuss your other 2 issues.
Yes, sir. If we are correct that the non-claim statute should be told, we believe there is ample consideration to support the Glenn versus Fleming agreement. This case is unlike the Canada cases. Here, there was a lengthy negotiation between counsel for the estate and Autumn's counsel, my co-counsel, Mr. Sanders, on the terms and conditions. There were promises given. Autumn, who was not the petitioner in the estate case, agreed to pay not just the administrator's fees and expenses, but any attorney's fees and expenses.
Now, is that the assignment you're speaking of?
I'm talking about when the estate was opened, Your Honor. Autumn was not the petitioner in that case. The statute in Kansas says the petitioner who opens up an estate can be responsible or is responsible for the fees and expenses of the estate administrator, but that was not Autumn. There's nothing in the record to say that was. So her agreeing to pay those fees and expenses in and of itself is consideration. Plus, you have to factor in the point Autumn was a minor. She could have disavowed the Glenn versus Fleming agreement when she turned 18, and she elected not to. That, too, is a decision that constitutes consideration. Lastly, on the judgment rule, the district court cited, let me make sure I get the case name right. Yeah, the Schropp case, and said, Well, the judgment rule really only applies in a first-party case where the insured brings a claim against the insurance company. But we've cited multiple cases in our brief that were actually the third-party situation that the district court said Schropp didn't apply to. So I would respectfully submit in that respect, the district court committed error. And with that, I thank you for your time.
May it please the court, Adam Hall for the Appellee Farm Bureau Property and Casualty Insurance Company. I think as the court has correctly identified, the standing of the plaintiff will rise or fall with the effectiveness of the assignment which the plaintiff purported to receive of the cause of action available to the estate to sue Farm Bureau for what the plaintiff has alleged is bad faith breach of the insurance policy. The plaintiff lacks standing, however, because the contract under which the plaintiff purported to receive the assignment of the estate's cause of action lacked consideration. And there are two principal bases on which the plaintiff has contended there was consideration for the agreement, both of which demonstrate hollow or illusory promises on the part of the plaintiff to the estate, rendering the consideration invalid. The first was the plaintiff's promise not to execute on the...
I'm sorry.
Sir?
Please repeat that.
Sure. The first was the plaintiff's promise to the estate not to execute on the estate's assets. At the time that the plaintiff's promise was made, the Kansas non-claim statute had already barred, on its plain language, all creditors, including the plaintiff, from removing any property from the estate. The plaintiff's second promise was to pay the estate's administrative costs.
Are you going to talk about that more?
Sure, of course. So
Well, that was the main thing that opposing counsel argued, is that the tolling for minority, at least for 8 years, would still apply. And counsel said he hadn't seen any cases in Kansas or elsewhere that address that issue. Do you have any authority one way or another?
Yes. We've cited a number of authorities, both primary and secondary and brief. But I think it might be of use for me to explain the harmony and policy that exists within Kansas law between both the non-claim statute and the general statutes of limitation governing the filing of civil actions in Article 5 of Chapter 60 of the Kansas statutes annotated. So the Nelson case that Judge Kelly mentioned during Appellant's argument discusses the development of Kansas's non-claim statute historically. At one point in Kansas's history, the Kansas non-claim statute had provisions which would permit its tolling for things including infancy, which would include the minority of a potential creditor. Kansas eliminated within its own non-claim statute any provision for tolling for minority. Kansas then adopted a code of civil procedure very similar to the federal code, including statutes of limitation. The general statutes of limitation there had an exception for tolling for minority. Kansas's current non-claim statute in Chapter 59 is a harmony of those two policies. In subsection 1 of KSA 592239, the Kansas legislature sets forth the general rule. That rule is any claim not brought within 6 months of the death of a decedent will be barred, and no estate asset may be taken by that creditor. Subsection 2 offers a refinement, a compromise, a specific policy set forth by the Kansas legislature to harmonize its general rules of statutes of limitation within Chapter 60, along with its non-claim purpose. So I think, as mentioned previously by this court, there is a legitimate function mentioned in several cases cited by both parties, a legitimate governmental purpose by the state to close estates on a relatively swift basis. A competing policy would be one that would disadvantage minors who are victims of tort at some time during their minority to and otherwise to allow individuals to recover from insurance policies that may have been held by the decedent after their death. In that instance, the policy of the sort of probate policy, which is we want to get the decedent's assets determined and distributed to beneficiaries, is not really implicated because the insurance proceeds are not really funds which are belonging to the estate, which could be distributed to beneficiaries. Instead, they're funds that might be available to a potential creditor.
You say they're not part of the estate.
The funds are not part of the estate, that's correct. So subsection 2 of KSA 592239, its synthesis, its compromise, its expression of policy is that the Kansas legislature maintains the general 6-month non-claim period for all claims made against estate assets, with the exception that any claim may be brought within the general statutory limitation period against a personal representative of the estate, and that the sort of effect of the enforcement of that claim cannot affect the distribution of the assets of the estate. That is another way of saying you can get the insurance proceeds, which don't really service the policy of getting an estate closed quickly, but can compensate creditors who may have been injured by the decedent during the period of their lifetime on the same basis as you might have during the lifetime of that decedent, meaning within the general statutory limitation period set forth within Article 5 of Chapter 60. So the tolling provision of KSA 6515A would apply to the general period of time available to a minor to bring a claim against an estate, but the only thing they could recover from that estate, the personal representative, would be the insurance proceeds. Now, subsection 2 specifies that nonetheless, if you bring such a claim within the 6-month non-claim period, you can recover not only the insurance proceeds. This, of course, is by implication. It doesn't expressly state this. You could recover not only the insurance proceeds, but potentially an asset of the estate. But the timeline in this case demonstrates that that's simply not the scenario before the court. The scenario before the court is no estate was even opened until well after the non-claim period had passed. And the only purpose for opening an estate in this case was to then sue the estate's personal representative. So this is not a situation where an estate was opened for the determination, marshaling, and distribution of estate assets to beneficiaries. Its sole purpose was to open an estate, assign a personal representative for the purpose of being sued, and to obtain a recovery against that individual.
You know, part of what you had just said is I understand, and I want to make sure I get it right, is that if the general statute of limitations would otherwise expire sometime within that 6-month period of the non-claim statute, the statute of limitations would be tolled until the end of that 6-month period. Right or wrong?
I actually have not endeavored to answer that question, and I think I may have confused Your Honor. So let me go back just a little bit.
Well, that's okay.
My purpose in expressing that policy, which is indicated in one of the secondary sources, several of the secondary sources cited, including the Kansas Probate Administration Handbook, is just to point out that the legislature has wrestled with this question, or so it appears from the plain language of these statutes when they are read together, which I think is essential to a complete understanding of their purposes. In order to effectuate the legislative purpose of closing an estate and claims on the estate within 6 months, the legislature has the general rule of the non-claim statute. The legislature has established in subsection 2 an exception to that non-claim rule, but that exception is limited. It allows a recovery by a claimant against the estate of insurance proceeds, but does not allow a recovery against any of the estate's assets unless that claimant also filed their action against the estate within the non-claim period, in which case there could be a recovery of both insurance proceeds and estate assets. Here, while the plaintiff could take advantage of the tolling provision for the purpose of the general statute of limitation within Chapter 60, within the civil statute, there is no tolling statute for the non-claims, for 592239. And in addition to the general harmony, that general sense and policy which has been expressed by the Kansas legislature, which can be seen when reading those statutes together, the fact that the Kansas legislature specifically struck its own exception for infancy to the non-claim statute further supports that interpretation of Kansas law and should be the interpretation adopted by this court. The second promise that the plaintiff made to the estate is also an empty one. The plaintiff's promise to pay the estate's administrative costs and attorney's fees is empty because Kansas law already required that the petitioner pay any costs associated with the opening of an estate under those specific circumstances contemplated at KSA 592239 subsection 2. What's important is the remainder, is the construction, is that rule, petitioner pays costs, connected with the ordinary rule that exists under Kansas probate law in elsewhere. So normally, in Kansas, when a petitioner opens an estate, the person paying all costs associated with estate administration and costs under our probate code includes attorney's fees for the petitioner's counsel. The ordinary rule is that the estate pays those costs. But in the context of an estate opened by a creditor pursuant to 592239 subsection 2, we know that the legislature's policy at this point is, no, we're not going to allow you to take any further assets of the estate. And we know that that estate is being opened just for the purpose of establishing a defendant which may be sued by a creditor in connection with a tort claim. We require that that creditor petitioning to open the estate for that purpose pay the cost associated with the administration of that estate.
He says that Autumn isn't the petitioner. What's your response to that?
Well, if the court reviews the pretrial order and the party's stipulation of facts, it does not say that Autumn was the petitioner. It does, however, say that Steve Sanders represented the family and that Sanders is the one who opened the estate. I don't think there's any reasonable inference to be drawn other than a person who who was Autumn's agent is the petitioner who otherwise would be required by Kansas law to pay the costs associated with the opening of the administration, including the attorney's fees which had been incurred and which the plaintiff is claiming would constitute consideration for the contract. With those two promises.
The facts you just recited, you said that's in the stipulated facts or the findings, but what?
Yeah, it's in the stipulated facts of the parties within the pretrial order.
So if they had put in for $1 and other valuable consideration and then went on with the assignment as it did, they'd be standing.
If consideration had been exchanged between the parties as defined.
I mean, if they said for $1 and other valuable consideration, that would cover it, wouldn't it?
Potentially, yes.
Okay.
And consideration under Kansas law is a little more complicated than that, and certainly it would presume consideration under that circumstance.
Does the Granados case have any bearing on this case at all?
Not on the question of standing. So
no, I know. Yeah, I'm switching gears.
In Granados, the Kansas Supreme Court recently declared that the duties owed between insurer and insured, rather the duties owed by insurer to insured, are much broader than had been previously suggested by Kansas law. The Kansas Court of Appeals and the Supreme Court and some of the decisions of this court suggested very discrete duties, like a duty to initiate settlement. And the Kansas Supreme Court in Granados, as I understand it, said it's a broad duty. It's a duty of good faith. It's a duty of reasonableness that can include extending settlement, but maybe not, largely relegating to fact issues those issues which could previously be resolved legally. But I don't see the application to what I think is the issue this court is deciding related to standing. I don't see application of Granados.
Okay, thank you.
If there are no other questions, I would ask the court to affirm the district court and determine that the plaintiff lacks standing.
Thank you, counsel.
Should we start the Tuesday cases now? I mean, the Thursday cases? Just go right into them?
Take a minute here.
Oh,
Sorry, 59 seconds, I won't be long.
No.
I want to agree with something Mr. Hull said when he said the legislature has reckoned with this issue. And I'm going to agree, but for a different reason. I'm going to agree because the legislature is presumed to know that the non-claim statute was on the books. It has been in Kansas since 1939. Section 60-515A didn't go into effect until 1963, and in 1992 it was amended. And the prefatory clause, it says, except as provided in KSA 60-523, and then the statute appears. Had the legislature in Kansas intended the non-claim statute to apply to 60-515A, it would have added the non-claim statute after it added section 60-523. So I agree, legislature has spoken on it, and that's why the court should reverse and remand for a new trial. Thank you.
Thank you, counsel.
okay.
Thank you, counsel. Counsel are excused. Case is submitted. Court is in recess till 8:30 tomorrow morning.